Pronouncement of judgment, item number 1.
From a perusal of the above-mentioned issues, that means trial court issues, it can be seen that regard to inheritance and eviction of sold property, on which substantial questions appear to emanate from, the same are contained issues number 16, 17 thereof. Accordingly, two issues are set against the questions as framed will have to be examined as to whether a substantial question of law has arisen. At this juncture, it is to be noted that while adjudicating second appeals, is important to keep in mind that for a question of law to be substantial, the same must be debatable, not previously settled by law and precedent, and must have a bearing on decision of the case on the rights of the parties. Further, to be a question of law, a foundation for the same must exist in the pleadings, and the question should emerge from the findings of fact arrived at by the courts below, and the same be necessary to be decided for a just and proper adjudication. The instant appeal has been preferred from the concurrent findings of the courts below, whereon the findings of fact both the courts below had decided the matter in favor of the respondent. First, issue number 16, whoever is held as per Khasi custom, ancestral property should be inherited by youngest daughter of the family, and inheritance be only from the line youngest daughter, the same which has also been admitted by defendant number 3, mother of the appellant in her cross-examination. Secondly, issue number 17, Law Appellate Court had upheld the findings in the trial court, also digested issues number 7, 8, 9, so and so, and coming to such findings wherein the trial court recently issue had come to finding that suit property was neither gifted or alienated to the defendant number 3, and first suit property was entitled to be inherited only by the direct descendants of the original deceased owner of the plaintiff. For examination, the issues of frame of trial court and findings which have been rendered application of facts and evidence were revisiting the same, inasmuch jurisdiction of this court being confined to substantial questions of law, wherein findings of fact are not open to challenge second appeal, this court now progressed to address so on and so forth. Having heard the counsel for the parties and having considered the concurrent findings arrived by the courts below on the hard facts of the case which contain issues number 9, 10, 11, 13, 14, 15, is seen the finding of the trial court setting aside the mortgage created by the appellant's mother and also deed of declaration have been arrived at after a thorough examination of the facts while keeping the principal Khasi customary law in mind, and does not need further discussion. The eviction as decreed also was based on the peculiar facts of the case itself, and such consideration of the court. No general question of law has arisen there from the required education. Further, substantial questions are framed, not being the basis of the pleadings and issues of the suit. This court finds that no substantial question ought to be decided, and an appeal seems dismissed. Lower court sent back.
Raj.
Yes.
Any mention?
May we please, Your Lordship. Your Lordship, I beg to make a mention for item number 44, Your Lordship.
Number?
44, Bella Kishan, Your Lordship. Your Lordship, I am appearing for respondent number 6, State of West Bengal.
Number 44?
Yes, Your Lordship. Bella Kishan.
How many matters are today? Yes.
Your Lordship, I am appearing on behalf of respondent number 6, State of West Bengal, Your Lordship. Your Lordship,
Why is seeking time?
Your Lordship, actually, the conducting counsel, Your Lordship, he is the AG of Mizoram. So today they have an important cabinet meeting there, Your Lordship.
That's not yes.
My lord, the counsel for the petitioner, senior counsel, had called Mr. Tiwari, my lord, and he had informed, and that is why Tiwari.
Objection.
My lord, there is some objection to the matter.
What date do you want?
On 25th, my lord. There was a consensual date of November.
We'll see. That's open news.
25th of November.
What is 25th November?
Much obliged, my lord.
Highly obliged, Your Lordship. Good day.
Oh, my lord, I also beg to mention item 48 and 49, my lord.
Why?
My lord, these matters files I've taken home to study, and then I forgot at home only. So just a week time, my lord.
48, 49?
48, 49, my lord.
So yes, bad. You know, we had a client before, you know, for a suit in Tura, So like, he came and said no. So we drafted the plan for him, kept everything in the file. And while going to Tura, he got down to have food in this place called Paikan. No? He reached Tura, I found he left the file there. So not same situation.
I left it. I left it on my table. Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item 37 in the hearing list. This matter may kindly be passed over to Wednesday, Your Lord. Day after.
First 37. Why?
Well, Lordship, today I have to attend my local festival.
Then after 1 week, you come.
Right.
May I please, Your Lordship, I beg to mention item number 41, Your Lordship. I'm appearing on behalf of Mr. Arjun, Your Lordship.
41 on behalf of Mr. Jha.
Yes, Your Lordship.
Yes. Who's appealing for? Who's appealing for a union? That BSF matter that is hanging for some time now, that Babita Das.
Your Lordship, here we're still awaiting instructions. Also, the matter is being examined.
But they've issued some similar certificates to others,
2
despite
weeks.
the fact that there is no such policy.
Yes.
After 2 weeks, Your
Yes.
Lordship.
Your Lordship, I beg to mention item number 46.
Why?
The conducting analysis is not available, Your Lordship.
Not well, he's not well.
Yes, Your Lordship.
3 weeks, okay. Yes.
Obliged, Your Lordship.
Yes.
Milords, I beg to mention a fresh matter for urgent listing, Milords. This is against an order passed by the Special Judge Jovai, whereby he has summoned, Milords, half a dozen officials of high-ranking officials of the government, Milords, in contravention, Milords, of or judgments passed by the Supreme Court and provisions of the CRPC, Milords.
With regard which matter? Criminal matter?
Milords, it's a matter pertaining to closure of the FIR, but we are challenging it under 227, Milords. It's completely falling under the superintendence of powers of the High Court.
For today?
For today, Milords. Obliged, Milords.
Lordship, I'd like to mention item number 38, Lordship.
38.
Yes, Lordship. Lordship, kindly allow us some time because 2 of the petitioners have expired, Lordship.
They've expired?
2 of the petitioners.
Have expired?
2 of them, Lordship.
Yes, Mr. Kharkarang, let me counsel with the petitioner. You petitioner, right?
Yes, Lordship.
You're for a petitioner?
May please,
Yes.
Your Lordship.
Lordship,
Before item 39.
39, Lordship.
38.
Oh, 39.
They are the pensioners, Lordship.
Acha, Livingstone Rambai.
Yes, Lordship.
Oh. Mr. R. Kharkarang, let me counsel with the petitioners. So, with please, the matter be adjourned as 2 petitioners have expired.
Yes, Lordship.
To enable to obtain instructions. Only list the matter after 3 weeks, yes.
Then force 40 will have to go, Your Lordship, because it has been tagged along with this matter.
Just to counsel
Correct,
matter,
Lordship.
They are pensioners.
Yes, Lordship.
Obliged, Your Lord.
Did they get pension before they died?
Till December 2023, they've received, Lordship. But
Very sad, yes.
Lordship, I beg to mention item 53, Lordship.
Number?
53. It's a joint request.
53. On the other side. Any urgency?
It's ACR matter, Lordship, promotion.
3 weeks, yes.
Hello, Lordship.
The request was answered.
May I please?
Yes, make up your mind.
Your Lordship, I'd like to mention item number 51, Your Lordship.
Yes.
Kindly, this matter may be taken up after 2 weeks.
You've informed the other side. You're appealing for the petitioner.
And for 51, I file an application, Your Lordship, for impleadment as necessary.
The CRP 11/2024.
They have filed an application for impleading.
We take that up first. Has been taken up.
As the conducting counsel, Your Lordship, is having some personal difficulties. I pray that this matter may come up after 2 weeks.
2 weeks. And on the prayer of Philip.
May I please, Your Lordship, I beg to mention item 52.
Yes.
I pray for 2 weeks' time, Your Lordship.
Praying for?
I pray for 2 weeks' time.
Why?
The conducting counsel is indisposed, Your Lordship.
It'll be 3 weeks, Your Lordship.
Yes, Your Lordship.
Okay, 3 weeks.
It'll be 3 weeks, Your Lordship.
No urgency?
No urgency, Your Lordship.
Apply, Your Lordship.
Much obliged, Your Lordship.
Please, Lordship. Sir, I beg to make mention item 43, Lordship.
53?
43, Lordship.
I'm mentioning, you're mentioning Shabazz Qureshi again?
Yes, Lordship.
He's been adjourning it repeatedly.
Lordship, they have filed a missed case with regard to starting
Who
of
filed
a
a missed
petition.
case? For what?
Lordship, I filed a missed case.
For pleading?
Yes, for withdrawal. I'm not, I no longer...
Yes, we'll take it up, we'll take it up.
Senior counsel have some difficulties today.
Huh?
Senior counsel have been...
Yes, Mr. Jindal. Mr. Shabazz Qureshi himself has filed a petition for withdrawal.
Yes, Your Lordship.
Then what's your problem? Have you been disengaged by him, that means?
No, because there are two petitioners. There are two petitioners. So from those two petitioners, one petitioner
I'm the
wants
number
to
one
withdraw
petitioner.
himself.
Yeah.
Which one is this?
Shabazz Qureshi.
The first one?
Yes.
So petitioner number 2 remains. So the list remains. The matter remains with this court.
So we'll take up the missed case first. So have you been disengaged by petition number 1?
No, Lordship, you have to take instruction.
You're still representing him?
Yes, Lordship.
Mr. Datta is representing him?
Yes, Shabazz Qureshi.
Yes, so he's got 2 lawyers, one to pursue, one to withdraw. Or what is the situation?
Take instruction.
Take down, what missed case number is it? 185?
I don't know the number.
185? The one filed by you, Mr. Datta.
See the number.
185.
185.
Yes, Mr. Digi Datta's missed case number 185 submits that the petitioner, the applicant, who is the petitioner number 1 in WC 26/2023, but his application seeks to withdraw himself from the writ petition. Stop. Next para Mr. S. Naitang, who's appearing for the petitioners, submits he has no instructions. He prays allowed 2 days time to obtain instructions. That's the matter on Wednesday. Yes. And we'll finish up this matter. What is there? It's been just lying there. Yes.
Similar prayer for item 54, Lordship.
Number?
54.
44 already been adjourned?
54, madam.
54, Lordship.
Here, my lord, they have not filed the rejoinder also, and not, so they have...
Filing the course of the day, Lordship. Course of the day, Lordship.
3 weeks, yes.
Similar prayer for item 55 as well, Lordship. This is a verification of job card, Lordship.
3 weeks, no urgency?
2 weeks,
yes.
Lordship. Interim may continue, Lordship, in item 55.
Yes?
Interim with...
then we'll vacate interim order.
55.
And
2
then
weeks, Lordship.
You vacate it?
No, Lordship. Give it 2 weeks' time, Lordship.
We'll hear it. This, what job card matters, it won't take long. 2 weeks, okay. Yes.
Lordship, I beg to mention item 50. Lordship, matter is in the hearing column, but we are required to file a rejoinder. I'll be filing it in the course of the day, Lordship.
File it. You've given copy to them.
It's prepared, Lordship. We'll file it in the course of the day. I'm praying it may be taken up after 2 weeks.
Yes, Mr. Deb submits that China will file the course of the day. He prays the matter after 3 weeks. Yes.
Much obliged.
Yes.
Item number 2.
No, please, Your Lordship. Your Lordship, this is a contempt petition. The contemptors has violated this honourable court's order.
Which one?
Your Lordship,
Where,
the
sorry,
order...
which page?
Relevant page is at 20, Your Lordship. The order dated is 1st May 2024. The relevant part is page 20, Your Lordship. May I read, Lordship?
Oh, para 4. Yes, Dr. Mozika.
I'll enter it as well. I'll file an affidavit.
4 months, yes. Heard MSP Chaitanya with consultation issue notice. Dr. Mozika accept notice on behalf of the respondents. Notice required. This after 3 weeks for instruction affidavit.
Obliged, Your Lordship.
Item number 3.
May I please, Lordship. Lordship, this is this petition, actually this is the petitioner is the wife of the deceased employee. The deceased employee was working as a warden in the district jail, Riboy, Your Lordship. As a warden. It's a regular employee. Warden.
Okay, warden.
Now what happened is, actually I'm not legally married to this employee, but we have been in relation since for about 12 years. Out of our relationship, we have got 4 children also. Now we are, due to some difficulties, we didn't legally married. However, Lordship, there is no other wife. I'm the only wife, and then the 4 children. Now the deceased died at his residence in Garu Hills. Therefore, they are not able to obtain the death certificate. However, he died on 10/12/2023. Thereafter, we have approached the responding authorities. We filed a representation. Dear Lordship, we have enclosed
They
it.
rejected that.
No, we are not enclosed, but still they have not decided anything. They have not response to our representation, Lordship.
Where's the representation?
Your Lordship, it is page 32, Lordship.
32?
Yes, Lordship. This is type copy. And,
This was filed in September, Your Lordship.
Just get instructions.
Yes, Your Lordship.
But it's a December issue notice, MS that you're the only, all possible
Your
respondents
Lordship.
except how all respondents know for them is required. It's after 3 weeks for instructions and evidence.
Lordship.
Obliged, Your Lordship.
Much blessed, Lordship.
Item number 4.
Yes.
Lordship, my senior counsel is having some personal difficulties. I humbly pray this matter may be listed after.
Where's Mr. Sen?
He's unavailable today, my lord. He's unavailable today, my lord.
After how long?
2 weeks, Lordship.
3 weeks. When?
After 1 week, my lord.
As the counsels appearing for, as the counsels appearing for the respective parties unavailable, just a matter of 2 weeks.
Obliged, Lordship.
5.
But you've given a copy of the affidavit to him.
We have received a copy of the
And then?
So, my
What instructions have you got on that?
The affidavit which has been filed by the union in reply to our affidavit, my lord, it shows that the entire work have commenced before the petitioner damage. That is what they say. So it is for the petitioner who should be aggrieved now, my lord.
The work commenced before the?
Before the, my lord, the work commenced after the damage. That is what we can see. So
In the process of the work, they dismantled my supply line, they dismantled my water tanky, and then
Was there any inspection done by the district officers together with the NHIDCL?
Yes.
Was done? Inspection was done?
Inspection, there was inspection.
Then, what does the report say? Is it there? In the affidavit, huh?
One inspection was done by us with the petitioner, and we have forwarded the assessment to the NHIDCL, and we have not received any reply to that. But in the affidavit, it is quite clear that they are not. They are saying that they are not responsible for the same because the entire work was started after the damage has occurred. So it was not at the.
You mean to say it's caused by natural causes, not by the road construction?
No, no.
That is what they are denying. That
They,
the damage was
their stand is there. But admittedly on report, so it has been reflected.
You have received instructions on the affidavit.
The only thing which we have been informed, because our affidavit was with regard to one paragraph in the affidavit of NHIDCL, saying that they have released money to the PHE department. To that context, madam, we have filed a small affidavit by the PHE department stating that.
No, but that's only with regard to the irrigation. There are substantial issues that the pan, like where they're growing all this beetle nut leaves, it's all been damaged by the construction.
Yes, my lord. To that extent, my lord, what we have done is that we have already made a calculation with the petitioner being present. We have already submitted the entire assessment, which has not...
So Mr. Sen come then, day after tomorrow.
We can, my lord, this week.
After 1 week, as the conducted counsel on behalf of the respondents 3 to 11 is in this post. This is matter of 20th.
He might be having problem on 18 and 19.
He's going to be sick till that time, you're sure?
There are other matters, it seems. Today he is not well, my lord.
There's on 20th, yes.
Item number 6.
May I please your lordship? Lordship, in this matter we need some more time. Please hand over. Just a minute. Lordship, today we are having a detailed meeting, your lordship.
Today?
Lordship, yes. So we need somewhat, at least allowed out us 3 weeks time, your lordship.
Mr. Initial Island EAG today has produced a communication dated 7 November 2024, wherein it is stated that the departments had review meetings within the department with the Chief Secretary on Meghalaya, and further a detailed meeting is scheduled on 11/11/2024
today,
to reply to the queries of the Ministry of Home Affairs. Mr. Indi Shulai submits that as the discussions, or as the matter is still under active consideration, the matter as a matter under consideration, let he prays that 3 weeks be allowed, for the time be allowed, yes. Accordingly, in view of the communication, just the matter of the 3 weeks for further orders, yes.
Lordship, yeah. Up to 16, then 30, 34, 35, 36, your lordship.
Okay.
Apply.
17. 17.
Please, Your Lordships. Your Lordships, an application has been moved under Section 379 BNSS.
It's for deposition today, correct?
For
you
evidence.
brought your
Yes.
witnesses?
Yes.
Please, Your Lordships, but before that, Your Lordships, I just wanted to highlight this application has been filed currently.
Perjury?
Please, Your Lordships. Your Lordships, I just wanted to highlight certain points in this application before moving on with the cross-examination, why it is important to first adjudicate this application before conducting the cross-examination. Your Lordships, kindly have 5 minutes. I just want Your Lordships to go through this application.
You've given copy, you've been served?
Yes, Your Lordships, they have been served.
Substantial to see on it?
Absolutely. It's premature. It's premature. Cross-examination can take place. In fact, it should take place for the petition to be maintainable. I'll substantiate, my lord.
Yes.
Please, Your Lordships, before this application, a brief background would be that the respondents had filed an application under Order 7, Rule 11, seeking rejection of the petition, saying that the election petition was not filed in consonance with the terms of Section 81 of the Representation of Peoples Act. Now, Your Lordships, the main issues for before Your Lordships for consideration was that whether the election petition was personally presented and personally presented before the stamp reporter. Your Lordships, wide order dated 19th of June 2024 were pleased to refer the matter for evidence, and now the cross-examination had to be conducted. Now, Your Lordships, in the Order 7, Rule 11 application, a show cause reply was filed by the petitioner. Your Lordships, kindly have page number 9 of my application.
Yes. 9, what do you say?
Yes, Your Lordship. Page number 9 is the show cause reply, dated 4th of July 2023. It is duly notarized also, Your Lordships. Now kindly have page number 15 of the application. Para 11.
Yes.
Para 11 reads, Your Lordships, that the averments made in paras 9, 10 and 11 are entirely false, concocted, unfounded, frivolous, misleading and denied. It is humbly submitted that the petitioner herein has himself personally presented the election petition before the Assistant Registrar Srimati S. Lanong of this Honorable Court on the date of filing, that is on 21st March 2023, and as such there is no contravention of Section 81 Clause 1 of the Act 1951 and or Rule 1 of Chapter 8A of the Guwahati High Court Rules. Your Lordships, in terms of this para, the petition was personally presented before the Assistant Registrar S. Lanong. Now, Your Lordships, evidence affidavit which was filed at this is annexed as Annexure A2 at page number 25, Your Lordships, filed on 11th of...
Second. Now you say that soon he the petition respondent had personally presented election. Okay, fine.
Please, Your Lordships. The name, what I want to highlight before Your Lordships is the name of the concerned Assistant Registrar or Stamp Reporter as per the petitioners was Srimati S. Lanong, Your Lordships. Yes. Now, the evidence affidavit was filed on 11th of September, Your Lordships. That is as page number 26 of my application.
Yes.
Now, Your Lordships, kindly have page number 28, para 7.
Yes.
Now, the para 7 reads, Your Lordships, that I have personally presented the election petition before the stamp reporter. Yes, Your Lordships. Namely, Sunita Lingskor on 21st of March 2023. Your Lordships, this is an apparent false statement made by the petitioners on 2 affidavits duly notarized, Your Lordships. The show cause reply dated 4th of July was duly notarized, Your Lordships. Also, the evidence affidavit is also a duly notarized affidavit, Your Lordships. So this is the case where the petitioner has made false statements on 2 affidavits, Your Lordships, which makes the case for Your Lordships to take it as a perjury, because it is apparent that a perjury has been committed by the petitioner, Your Lordships. This is why this application is being moved before Your Lordships, and also because, Your Lordships, unless this issue is determined by this Honorable Court, cross-examination cannot be conducted, because the other 2 witnesses, they just accompanied him. And the petitioner himself personally presented.
In the affidavit, they've given the same statement. The other witnesses, how many affidavits
there are
have you filed?
3 witnesses. The
all
other
of them
2
have filed
witnesses.
identical affidavits.
Please, Your Lordships. The other 2 witnesses have also given the statement that the petition was presented before Sunita Lingskor, which is...
And the earlier one, in the objections, they've given the same thing, Sunita Lingskor.
Your Lordships, they did not make any earlier affidavit. This is the first affidavit they have filed.
So this is what they say.
Yes, Your Lordships.
Yes.
Therefore, Your Lordships, this application...
Yes, General. Why is this
Lordship, a bit of printer's devil appears to have crept in, but before I reply on the merits of the allegation that has been raised through this application, Lordship...
See, this is very crucial.
It is.
Because whether it's presented before whom...
It is.
I mean, how can he make a mistake with regard to the person who was manning the office?
Lordship.
If you say that S. Lanong was an assistant registrar stamp reporter...
Lordship.
Now...
Lordship, yes. Lordship, I cannot agree more with my lord that it is a very...
Maybe there's no... there's no need for an inquiry, but even
on the face of it,
it's that you've given wrong information.
I cannot fight with the record, but there is some printer's devil that has crept in. But before I respond on that, if Lordship allows, Lordship, my friend's concluding submission was that the cross-examination cannot be conducted without adjudication of this. Lordship, I beg to differ. This petition, Lordship may kindly see the miscase which has been filed today. It has been filed under Section 2, invoking Section 229 of the New Evidence Act, my lord. Now, Section 229, if Lordship kindly takes the trouble of looking at Section 229, 229. 229. 229 is the punishment for perjury, which apparently I have committed, my lord. 229. It is more or less a replication of 193 of the old Act, 229 of the new Act, my lord.
Yes.
I'll quickly,
All evidence,
I'll just read the first line, my lord. Just the first line, subclause 1. Whoever intentionally gives false evidence in any stage of a judicial proceeding. That's all I need to read, my lord. Now, what is required for 229 to be invoked, to be applicable?
Can I just see your book?
Yes, my lord.
Here is some printers, there were some omissions here also.
Okay, okay.
It is universal. Strange, there's a word missing here. Yes.
Lordship, what I was highlighting
Yes.
is that for 229 to be invoked, to be applicable at the threshold, what is required are three things, my lord. Intentionally gives false evidence. So, number one, evidence is required. Number two.
Now, but won't you say that your evidence and affidavit amounts to tendering of evidence?
No, evidence.
If you have come to a progress
Lordship,
examination.
Lordship will kindly appreciate.
Then we come and roll around to the earlier arguments, but whether
Lordship,
unless the witness comes on in the dock
Yes.
to depose or to
Yes,
prove the exhibits, like we can't take, but you're going to be examined on the basis of your evidence and affidavit, correct?
Lordship, Lordship,
Can it be considered a stage of evidence or evidence yet to begin?
we are at the evidence stage, but evidence has not yet come on record.
How?
I will just.
Then
I will just
you're
elaborate.
swimming into deep waters. Then you'll have to have 2 days of hearing on this.
No, my lord, it's a very simple.
They are very there are many decisions. We are aware of
Lordship
that.
Lordship will allow me. It's
What is the status of our evidence? And
It's a very simple. It's a very simple proposition I'm laying.
Yes, okay.
Lordship, the affidavit which I have filed, the chief examination, the contents of that affidavit are mere statements, my lord. Are mere statements. They will only be graduated to the status, to the designation of evidence once they are tested through cross-examination. Because a statement in chief examination, honorable court, or any other honorable court will not be in a position to take cognizance of that statement unless it is tested by cross-examination. Once it is tested and maybe shaken, etc., through cross-examination, it graduates to the status of evidence. Then honorable court can take cognizance and hold a fact to be true or not true, my lord. So right now, what is before my lord is a statement in the chief examination. Let the cross be conducted. Once the cross is conducted, she has to challenge.
See, they have come under 379 also of this BNSS, whatever.
That's a invoking power.
Right. Okay, fine.
Yes, my lord.
That's it. I mean, for whether we need to take an inquiry and for
yes, my lord.
So on and so forth.
Yes,
but the thing is that your statement that an evidence on affidavit does not constitute evidence. Now, what is the purpose of making of making this affidavit at all then?
Lordship,
now the thing is that, see, one thing you must
Yes,
remember
yes, madam.
that when you made this, when you wrote this affidavit,
Right,
whatever,
right.
you've sworn it before a notary.
Notary,
Then is that not on oath?
It is on oath.
Then
No, it
how
is on
can
oath.
it? So it's on oath before the notary.
It is
you
on oath,
come
madam.
here now. You see, it has to be. You have to be affirmed in yes, but only on cross-examination. Correct? Because you already tendered your evidence and affidavit.
Lordship, Lordship will kindly appreciate, under normal circumstances when Lordship is maybe exercising writ jurisdiction, statements made on oath are good enough
No, we can't differentiate. On oath is on oath.
Because this, my lord, is a trial governed by rules of evidence, etc.
But then, Mr. General,
Yes,
I am sure there are conflicting decisions on this aspect.
Uh,
Whether
yes,
an evidence, an affidavit,
yes,
whereby evidence is given, whether it can be taken, in toto to be evidence as
cited a
tendered
judgment
and
also.
subject yourself to cross-examination.
My lord, when
But
I
then
make
if that is the case in every trial and an affidavit is filed, then again you'll stand up and
Lordship,
I can understand if you have annexed certain kind of like documents which we have to be proven. Okay, fine, you
That-
prove it. Yes,
that is
the thing
that's
that you
a
prove
different thing.
signature.
That's a different thing.
Or you
That's a
prove
different
something else, right?
Yes,
that is part. It supplements the evidence on affidavits you've given.
ma'am.
But to say that that totally it's fresh is nothing.
My lord,
then why tender your evidence affidavit at all?
My lord, my humble request to this honourable court is to kindly appreciate one procedural reality, which is that when I file my chief examination, supposing for whatever reason I am not cross-examined on that chief examination, That chief examination cannot be taken cognizance of by
How
the
do you
Honourable
say that?
Lordship. There is law to that effect, my Lord. Lordship will kindly allow me to file a small reply to this. I'll bring out everything.
Lordship, there is
Then we can't proceed with the evidence.
No, Lordship. So the intention, the reason behind highlighting 229 was to show that first evidence has to come. My humble submission.
Exactly, and if the court is still undecided whether we can consider this evidence now, can we consider this evidence has yet to come, or has it already come?
Evidence.
It's come on record. It's notarized. It's sworn before.
Evidence. My respectful submission, which I will attempt to substantiate through the law, is that evidence, the status of evidence to a statement can only be given to a statement which has been tested through cross-examination. There is law to that effect, my Lord. Lordship will kindly allow me to file a small reply. In the meantime, there is one more fundamental flaw with respect to with this application. Lordship will kindly recall the same flaw existed in the previous Order 7 application also. Chapter 8 of the Guwahati High Court rules, my Lord. Chapter 8, Rule 10 requires leave of this Honourable Court before filing of any sort of miscase, my Lord.
Your Lordships, that was taken.
Yes, they have not filed a leave. They have not filed leave. Have they filed leave?
Your Lordships, we will do that.
It cannot be post facto.
Your Lordships, that was done.
It
The
cannot be,
formality was done before moving the application, Your Lordships.
Where is the leave, my Lord?
Your Lordships, that would
Where is the leave? The petition has been filed. Petition is being argued. There is no leave. So Guwahati High Court rules, Chapter 8, Rule 10. I'm not carrying it, but it is there. Very clear that before filing any miscase, leave of the Honourable.
Let's see that. Yes.
Yes, madam.
Your Lordships, that issue I would address, but before that, Your Lordships, the examination in chief being on oath, Your Lordships. There is a judgment, my learned colleague has gone to take out the copy of the judgment, Rasiklal Manikchand versus MSS Food Products, Your Lordships. That is 2012, Volume 2, SCC 196. Your Lordships, that judgment is very clear, which says that where the examination in chief of a witness is produced in the form of an affidavit, such affidavit is always sworn before the oath commissioner or the notary or judicial officer or any other person competent to administer oath.
This court, that's the only thing that's troubling this court, whether that will constitute as an
Because, my Lord, if the statement is not cross-examined, Lordship will see what will be the result. Supposing this Honourable Court comes to the conclusion that indeed I have committed perjury, then the next course of action is to refer me to a magistrate.
No. That's only if the court is satisfied that you have committed perjury.
So
then we ask the magistrate to conduct an inquiry again as to whether that's part of procedure. But the only thing you have to cross the initial obstacle you have to cross is whether and the affidavit you tell evidence whether it's that means not evidence at all.
Lordship, that is exactly my point. Lordship will have to be convinced that I have, on the face of it, committed perjury for reference to the magistrate.
It
so
can
for
be
this,
perjury also. Maybe this court can decide also, notwithstanding anything else, accepting your evidence affidavit, but then it's not necessary for inquiry because on the face of the record itself, maybe it's a
true, my Lord. So my point was, my Lord, for this Honourable Court to be satisfied, I have to stand in the box and explain this apparent contradiction. So maybe there is an explanation that...
Explain by how that you don't know the person?
Lordship will kindly allow me to hold on to my cards, but if there is an explanation and because...
That's an explanation. That's what you're seeking to evade it by saying what? By saying that we're putting your witness on the dock, say, oh, I'm sorry, I thought, this is Mr. X, is Miss X, but it's Miss Y. I'm sorry, so we stuck out in the records, the attendant, that she's Miss Y.
Lordship will kindly...
So that's very simple. But then firstly, you have to cross that hurdle whether we disregard your entire evidence.
Lordship, so they have to first...
You're not permitted to recall it also.
No. That's a different thing. Lordship, my points are two, my Lord. First, the petition is premature. Number two, it is not maintainable.
You're right. Then you file your objections. Then we have to suspend your position for today.
The cross may not be suspended because the intention behind filing
this... It defeats everything then. Whatever they've set up will defeat everything. If we cross them, then it comes up with a statement. Then that comes in addition to the evidence and affidavit.
My point is, my Lord, if I'm found...
Are you trying to correct the defect by putting the person on a dock?
Because he has to be challenged, that this is the contradiction. How do you explain this contradiction? Maybe he has an explanation for that, my Lord. He has to be allowed...
by what you said.
He has to be allowed to explain himself, my Lord. How and why has this contradiction come? In any event, Chapter 8, Rule 10, my Lord, this petition is, on the face of it, clearly not maintainable.
Interesting point, but Are you interested in pursuing the selection petition?
We are here, my lord. We are heavily contesting it.
But by the conduct of all the past hearings, it seems that, Anyway. Rule 6.
Rule 8, Rule 10, my lord. Chapter 8, Rule 10, if memory serves correctly.
Once I know.
Rule 10.
Yes, 10. Yes, you have not taken permission.
Your Lordships, I would satisfy your Lordships on that.
Then
issue.
we are just swimming in circles. You file your short reply. Whatever she takes objection also, whether we reject it or we accept it, Mr. Jindal.
Yes, yes.
Yes. Take down this Miss So-and-so case. It's not registered as yet. It's been filed under Section 379 of the Bharatiya Nagrik Suraksha Sanhita 2003, read with Section 229 Bharatiya Nyaya Sanhita. That's just right, BNSS and BNS. But I pray that for the prayer for initiation of criminal proceedings under Section 229 of BNS against the respondent for intentionally giving false evidence for the purpose of being used in judicial proceeding for honorable court. Stop. Next paragraph. Heard counsel for the applicant. Stop. As also for the election petitioner stroke respondents. Mr. S. Jindal prays funds allowed 1 week's time to file a reply. Otherwise, you have to, use all your tricks of advocacy.
Which I'm attempting, my lord. Obliged.
Around this.
Obliged.
Deeply obliged, your Lordships.
The cross is deferred.
Cross is deferred. Cross is deferred. In view of the application file, the cross is deferred. It's date to be fixed subsequently. Yes.
Grateful, your Lordship.
18.
Correct respondent the file affidavit.
My lord, I'm praying for a week's time.
Where the petitioner? On appeals of the petitioner, Dr. Emergency please for out 2 to 3 weeks' time to correct the affidavit.
19.
Yes, Mr. Sama.
Lordship, this is actually...
I'm praying for some accommodation for today, Lordship.
Why? Was it for today?
This is actually for order, right?
I know it's for orders. What kind of orders?
Actually, the GHDC and the state respondent, they have no objection with regards to the restoration petition, but they have with regard to the petition for restoration. The private respondent, they have filed it, the objection to the restoration petition. Now the matter is it can be posted for hearing, Lordship.
899 days restoration?
Yes, Lordship. The delay is...
for default?
Yes, Lordship, because during COVID time, my Lord, there is only some 419 days something that delay was there actually.
So why we not present in the court?
No, Your Lordship, what happened actually, there was a video conference at the time of hearing. Maybe due to some personal difficulties, the counsel for the previous who has been appearing, I think he is pursuing, but then due to some difficulty, maybe technical difficulty, he was not able to present before the court. Therefore, it was dismissed on default.
What's this order annexure for?
Your Lordship.
Where's the order of dismissal first? Okay, first see the order of dismissal.
First, there's a page 13, my Lord.
All right. Will restore Mr. Changreso?
But we have filed an objection with the calculation by the applicant is not correct. According to him, my lord, the delay of filing this is there is a delay of 518 days delay. But when we exclude the time given by the Supreme Court, the total delay is 899 days delay.
899 days delay.
Lordship, according to their calculation, my lord, in their para
Okay, fine.
14.
When it was dismissed on 1/2/2021, when did you come to the knowledge of the dismissal?
We come to the knowledge of the dismissal order somewhere in the year of 2023, my lord.
The Nokma matter?
Yes, regarding Nokma matter. This is Akung matter, Your Lordship. Actually, it can be gone maybe because I have the merit in the case, Lordship. Because
what merit do you have in the case?
Because since from 1961 that I have been in Nokma, and then there was a long litigation. Long
when did they occupy the post? From when?
Now nobody is occupying. Actually, what happened because of there was a litigation pending before the.
No Nokma now. How is it possible?
My party is in the chair.
But is any proceeding still going on before the district council?
No, nothing as such, man.
Your Lordship, this
approach is challenging the district council order. Matter was dismissed, and they slip over.
And the order of council is in your favor.
It is.
Then they have not entered your name as a Nokma.
No, they have not.
I'm not having that specific instruction whether his name
You get
is
instructions.
entered.
Otherwise, 899. If they've been functioning now, 899 will be nearly 3 years.
Mr. Lordship, this is the judgment based.
Whether their name is entered in the
Yes,
record.
take down. This application has been filed by the petitioners for restoration of a matter that has been dismissed. That had been dismissed on 1/2/2021. The delay, it appears, is of 899 days. Mr. P.T. Sangma submits that the dismissal occurred during the time of COVID, which prevented the petitioners from appearing on the set date. Therefore prays that for the ends of justice that the matter be restored, more so as it concerns the office of Nokma, which he claims the petitioners have a meritorious case.
Merit of the case, yes, Lordship.
Mr. H.L. Sangreso, Senior Counsel, on behalf of the respondents, has also filed objection. When was the order passed by the district council?
District council, I have the copy of the repetition. This judgment, in the repetition, maybe
1617. So it was passed 1617, recognizing them as the rightful Nokmas.
Yes, Lordship.
Then there's no point.
No, this is
then
the judgment 4/6/2013. This judgment, it is in my.
We want to know you would come against which order of the district council? CEM.
Yes, CEM.
Para 2 of his application. Para 2 of his application he has made.
Para 2 of his misapplication.
Yes. Order dated 24
September
16.
16/3/2017, my lord.
Okay.
Passed by the chief executive member.
Okay.
We have
now
come against the order of
17. You came to this court. This is 17 orders. This is okay.
Then the repetition was filed on May 8, 2017, as per the record.
But now you have not been entered in the name entered.
Hopefully he must have.
Because if there are any subsequent developments, then his case goes.
It must have entered. Allow me to take instruction within a week.
Yes.
No?
Yet I submitted that the writ petition had been filed against orders which were passed in the years 2016 and 2017 by the district council, and the business will stop here. However, praise is allowed to take specific instructions as to who's occupying the post of Nokma presently. Yes. List after 4 weeks will enable the senior council to obtain the instructions. If they already since 1716
No, 17, 16, we are challenging, we are the petitioner in that particular.
We understand. If since 16, 17, since 16 they've been occupying the post, then what's the point? Now
No,
we're sitting
they are not occupying, my lord. They are not occupying.
Let me take instruction.
Yes.
20.
Give the order.
Kau kan asking ring road nokma. Yes, that is.
Authorized lordship.
Yes.
Your Lordship, in this matter, we are going to file our affidavit in the course of the day, Your Lordship.
What about number 6?
They have
1 to 5?
They have filed it. Go.
1 to 5 they file.
Government have filed it. Only government, Your Lordship, they have filed it or responded number.
Yes. MS Karshi please submit that affidavit behalf of number 7 filed at course of the day. On this matter after 2 weeks for rejoinder of
Yes,
if
Lordship.
any.
Lordship.
21.
Authorized lordship.
21.
My lord, this matter has become infractious, my lord. My grievances was non-release of my salary from January 2021. So now I've got an order, a copy of the order passed by the State Education Mission Authority as
That is a duly appointed teacher.
yes. And then 17 September, the state project director said that there's no reason for withholding my salary, so therefore the salaries are released, my lord. So, my lord, so this has become infractious. I have the order, my lord. It's not very legible, my lord, but I'll just pass.
Yes.
Oh, you have produced already?
We adjourned last time because you wanted to file reply.
Yes, Your Lordship. I have filed my reply, Your Lordship.
So you say that he's a duly appointed teacher.
Your Lordship, yes. But Your Lordship, the appointment of the petitioner is illegal, Your Lordship.
Then you have to challenge this new order then.
Yes.
Since that, see, have you got a copy of order 17 September?
We've already
Then you have
produced.
to challenge it. Yes, as the facts as they put in as on today. On the fact that they put in on today, Mr. P. Obin, the council submits that the petition been rendered infractious. A copy of an order dated 17/9/2024 also been produced, wherein the petitioner, wherein the respondents have stated that they have been established that a petitioner occupies one of the teacher's positions under SSA with no justifiable reason for withholding his salary. So, it is also stated therein that he is entitled to receive salary along with all outstanding payments, which should be processed promptly or further delay. In view of this development, this matter stands closed and disposed of as infractuous stuff. MSP Riatham, however, has still maintained that the petitioner has been really appointed. Liberty is given to her to assail the same and other proceedings if deemed necessary.
Obliged, sir.
Copy of the orders taken on board with part of the record. Yes.
22.
Join the file, Mr.
Your Lordship, we need some more instruction, so give us some more time.
Who will give you time to do what?
To file our agenda.
But you are not filed it?
Not yet. We haven't filed yet.
Nearly 1 month time. Yes.
We have filed already counters, my lord.
5, 6, 7, we have already filed.
Only to 5 and 6, 7 you file the agenda.
Yes, Your Lordship.
Give you kind of PS funds allowed further.
2 weeks time.
3 weeks time. To file the agenda, yes. Any interim order in your favor?
Not yet.
In fact, my lord, status quo should be maintained, my lord, in this matter. Why? Because some of the land, my lord, which is disputed, my lord, they are trying to sell it off, whether the headman. This is because there's another case that has been pending in the district council court, my lord. That case got it dismissed for default. This is from Riboy, my lord.
Near, in the
near Borongbong.
Mensan village. Lum Sentung is
close to Borongbong.
Riboy, Umroi part.
The way to sell the land. That's why it takes time for the rejoinder.
Yes.
So you can. That's why you have to sell the land.
Your Lordship is that some villager they are selling the land, so that's to ascertain whether it's in the Sentung village or within Mensan village. So that's the contention. As a Lum Sentung village, till now they have not get a proper boundary, proper jurisdiction.
1 second. But nothing about the land here. All you're asking for to recall the order 1612, direct respondent of 5 to withdraw sanad issued to headman. Or who's headman Lum Sentung? You're there.
I'm the headman. I'm the headman, my lord.
Lum Sentung.
Yes, my lord.
You're still functioning.
Yes, my lord. Because my content.
The respondents to call for fresh darbar. Yes.
That in the said darbar, they have not yet ascertained whether they have complied or not with provision of section 3 of 1991.
You mean to say the boundary has not been drawn?
No. That's not a fact, my lord. Here, my lord, what happened is Lum Sentung village existed even prior to the existence of the act itself, my lord. So that was our contention. So since it was not recognized, we are only asking for recognition, my lord, because the village was in existence since.
See, Mr. Harinder, just see this order. Just now we've seen it. That page 49, last paragraph. You want to de-recognize them?
This is what the intention is.
Yes, out of the de-recognizing Lum Sentung as a separate village at this stage unsettled issue. Hence, though there is no strong foundation to show that a million prior dictionary committee to comply with provisions of so-and-so, yet the EC is of the view that perhaps this, as a separate should be not disturb this movement. Under the compelling reasons whereby headman was able to show that hasn't been functioning as a village since 1998.
So 1998, we are already in existence. The act has not even come to that at that point of time.
Why? 91 the act came.
No, the operation, my lord, the operation, with effect from.
So they're functioning since, if that they don't unsettle.
The act came into effect from 17th May 2006, my lord. And since we also have a Lum Sentung SSA school, my lord. So this itself shows that Lum Sentung is an independent village.
No, but then as per the inquiry,
yes.
See, Mr. Khalindo, the same million clarification has supported the fact Lum Sentung was created with concurrence of Mensan village right from 2003. The same million long clarification submitted as many 11 lectures to support the fact Lum Sentung already functions full-fledged village. The documents submitted similarly were from various authorities, including government, departments, so better schools, Anaskati HDC, block development officer. That is why you're objecting. Why? Because you want to sell the land, Lum Sentung village land.
No, Your Lordship is the contention is that some villager from the Lum Sentung village, they have sent a representation to the parent village, that is my village, asking that to take us back to the parent village.
Well, that can't be consideration to de-recognize the entire village.
No, in that sense, Your Lordship allowed me
instructions. Otherwise, we will please hear this matter now only.
We will please our stand in the rejoinder.
Firing joinder, why?
we need to
You file
give
within
some-
1 week then.
Your Lordship.
Otherwise, this matter shouldn't be. You see, you can't keep this kind of thing hanging over the head of the villagers. Yes, Mr. Khanna prays for and is allowed 1 week for him to file the rejoinder. Yes.
Obliged.
23.
Obliged, Your Lordship.
Lord, here we have sent for fresh instructions from the Directorate, my Lord, because the instructions which we got from the DACO is not sufficient, my Lord.
From whom?
So we've asked for, sought for instructions
The pension
from the
matter?
officer. No, my Lord.
Yes. This is pension only.
This is regularization.
Regularization and pension, because the same people, group of person, they have already been appointed. They have already got it, and from this honourable court also.
My Lord, the orders which are being relied by my friend, my Lord, it does not say, my Lord, it's not a precedent, my Lord. The order is
Page
very clear.
31, another person, Kravitson, Napoleon, the same person, my lord. And then the page 31
The order
of
of
my
this honourable court is
annexure,
very clear, my Lord.
the repetition annexure,
Says that it will not set any precedent.
page 31, that the serial number 2, Napoleon, then the Napoleon Marak, then Kravitson, Sangma. I'm here, Singman Sangma.
My Lord, if I
All
take,
these people, they already got it. They have been regularized.
If I take, my Lord, to annexure 11,
So
page
why, you see, Mr. Sangma, from what the court, it is covered by alleged judgment of this court.
My Lord, will kindly see, my Lord, page 41, the last para, my Lord, para 7 of this honourable court.
The another judgment I have given.
It will take a lot of time, Mr.
Page 34.
Who's the officer in charge here? I'll call him.
No, my Lord.
We'll bring the file.
We have, no, my Lord, we have recently written to the
Otherwise, let him
Directorate,
come
my
with a
Lord.
file. We won't need affidavit also. We'll dispose it of.
My Lord, we've written, kindly grant some more time, my Lord. We've written to the Directorate, so we'll be getting instructions, my Lord. Because, my Lord, para 7 is very clear, my Lord, that this will not be a precedent.
Whatever it is, as prayed further 2 weeks time granted. Well, we'll call them, because these matters, you know, they can be settled by, let them come with a file of that person, we'll settle it. What is that?
Yes.
You won't need affidavit also. Why go to trouble of routing through government advocate to write affidavit, to write letters, sit on it, don't file affidavit, keep on asking for time, goes for 6-7 months. If we can finish it with the records, why not?
Lordship.
Yes.
24.
Must be Lordship.
Yes, he said it can be closed.
To file the affidavit.
So,
We have
but
already-
last time, who's this? Who made the submission?
The state, my lord.
Your Lordship, we will not file rejoinder affidavit against the government respondent.
Yes.
They're for the petitioner.
Petitioner, I'm for the petitioner, Your
So
Lordship.
what do you want to say?
We will not file rejoinder affidavit against the government respondents.
No, this, see, they said one thing, that the matter can be closed based on affidavit filed by the
By the
state.
state.
In fact,
Can the matter be closed?
In fact, my lord, that submission was made by my friend on the last occasion, based on the contents of his affidavit. Today morning, my lord, I received the copy of their affidavit. In my humble submission, my lord, there is nothing that shows that the matter can be closed. In fact, para 10 could be the para that they are referring to.
Who's leading you in the case?
Please, Mr.
Sir Qureshi, Your Lordship.
Where's Mr. Qureshi?
Para 10, if my lord kindly sees, quickly read, my lord, that the averments made in paragraph 10 of the writ petition answering respondent states that the respondent number 4 had declined the approval on the proposal dated nil dated 22 September 2023 for reconstitution of the managing committee without prior consent of the petitioner. The proposal was very much undisciplined in character, since there was a lack of understanding and coordination amongst members of the managing committee, and the tenure of the managing committee was not expired at that time. Respondent number 4 had issued a letter dated 8/11/2023 in response to the above proposal forwarded by the respondent number 5 so and so. Now, subject to correction, my lord, I assume that this is the paragraph that they're referring to. I had sent a proposal last year, in September of last year.
My lord, if I may interject, my lord.
Your
Actually,
lord-
we are referring to paragraph number 15, my lord.
May it please, Your Lordship. This is regarding the reconstitution of the managing committee, where the managing committee has already, the tenure has already expired way back in August 24. Then before the expiry of the managing committee, Your Lordship, then the respondent number 5 as the secretary of the Garikhana Madrasa, not of the school, of Garikhana Madrasa, had sent a proposal for reconstitution, appointing himself as the secretary in that reconstituted. So, Your Lordship, the petitioner here, Your Lordship, they had sent the list to the government for approval, but the government could not approve because it was contrary to the rules, Your Lordship. As per the rules, Your Lordship, the secretary of the outgoing managing committee has to submit the list, Your Lordship. But in this case, it was not done so.
Now, the person who filed it is the secretary of the Garikhana.
No, the person who filed,
I'm
the petitioner, he is the outgoing secretary, Your Lordship, who had sent a proposal. Who ought to have sent the proposal. But before he sent a proposal, the respondent number 5 here, Your Lordship, as a secretary of the Garikhana Madrasa, not of the school, Your Lordship.
Mr. Jindal's client.
Yes. He sent a proposal.
He jumped the gun.
Yes, he jumped the gun, and there was a case, Your Lordship, which had to be withdrawn because the managing committee's term had already expired. This is prior to the filing of this
Where is
case.
Mr. Qureshi?
I'll go inform, sir, Your Lordship.
In fact, my Lord, if Lordship allows me 1 week's time, because I've just received a copy of this.
A soft copy.
You know where then. You know in the picture.
Let me
a
take
soft copy
let me
had
take
been
instructions.
sent, right?
Let me take instructions, because I sent my proposal not in the capacity of secretary something else, in the capacity of president. In the capacity of president.
Not to send, Your Lordship.
You know very well how these things happen.
I know.
Yes.
I know. 1 week's time.
We'll not allow this manipulation. Yes. After 1 week term, we'll close it on the next. This is a matter of the 1 week to allow Mr. Jindal to put in an affidavit. Yes.
Item 25.
Lordship, I'm praying for 2 weeks' time to file my affidavit.
Gaubra matter?
Oh, Lordship, this is retirement benefits, Lordship.
Which one? Which GHDC?
This is Lordship.
He was working as what?
Village Council Secretary, Lordship.
Has he got a pension now?
No, they are not
When
giving the
did he
pension,
retire?
only the 2020, Lordship.
2020?
1 week, Lordship, because he is suffering from some illness, Lordship. He needs money.
It's 1 week for the time is spread. Allowed to the respondent file affidavit.
Master.
26.
Lord, my apologies. Lord, here the concerned officer is on medical leave. He is joining on Wednesday, my Lord. So if I am only granted time till Wednesday.
What's the matter about?
It's a pension matter, Your Lordship.
Pension
It will be
matter?
finalized.
Regularization, my Lord. Because it's pending. Regularization is pending, my Lord.
Why was the matter of Sessions Judge? He was.
My Lord, the proposal for regularization was sent only in the year 2000.
Why? What orders from District Sessions Judge?
She's working in as a stenographer, Your Lordship, in the office of the assistant.
One Wednesday, Mr. Kibu undertakes that the appeal will be filed on Wednesday. Just thereafter.
And you apply.
27.
Please, Lordship. Lordship, a week's time may be given, Lordship, to file affidavit, Lordship.
What's the matter about?
For selection and appointment in Assam Rifles.
Yes, sir. For the 2 weeks' time as prayed allowed. Affidavit.
Much obliged.
28.
Lordship, affidavit on behalf of respondent number 5 has been filed.
I'm first evident in Your Lordship. Lordship,
5 is?
State.
Data of agriculture.
5.
I mean-
1 to 6 and 9.
7.
All on behalf of all the respondents.
I'll be filing in the course of the day, Lordship.
Yes, MS E-Pasa for 7 and 8 submits after be filed on the course of the day. On behalf of other respondents, that is 1 to 6 and 9, Mr. Amuwen said the affidavit filed on behalf of 1 over 5 will suffice for the respondents.
I may be allowed to file a rejoinder if necessary.
Yes, Mr. SW is allowed to file the affidavit.
29.
Please, Your Lordship, I pray for further 1 week's time, Your Lordship.
Fourth time.
Is Nehu under lockdown?
Situation, yes, Your Lordship.
Even libraries closed.
I'm not sure. Libraries.
Because students at least should be allowed to go to the library to study. They're not only just agitating students. Almost everything's locked down. So what about those students are preparing for the examinations or not? So they can't access the library also. And what will they do if they can't study? Very unfortunate. Yes, due to the prevailing situation in the university, MSS Sharam prays he will allow further 2 weeks time to affidavit. Praise allowed. Don't worry, now they won't take the decision also.
Lordship, only thing, observation be made for the vehicles not to be disposed of.
I don't think anyone will take the decision now.
30.
Obliged.
We have taken steps with regard to spot number 4 and 5. And postal service says that the service has been delivered.
Number 5? 5 is whom? 4 is?
I'm appearing in the same of million.
As per my instructions, we did not file a affidavit also because Lordship, it will appear by the impugned order at page 64, annexure 15.
Yes.
The order was passed by the executive member in charge of Laka administration. This, in fact, relates to a boundary dispute, no doubt.
Between William and Soyong.
William and Soyong. What the executive member, Millet, unfortunately has usurped the power because under the Ilaka Acts, it should go to the tribunal. So there is no point of matter being.
What to do?
If Lordship please to set aside and refer the matter to tribunal, all the parties will have opportunity.
Will you dispose it off?
It can be disposed of.
By setting aside the print order by page number 60 and 64.
What will happen in the intervening period?
My village will continue to function, madam. It is dispute between the CMship and the Lingdoship, and I become the victim of that process.
No, are you under, now you presently functioning under whose jurisdiction?
Salan issued by the Lingdoship.
Now under Lingdo?
Yes, yes.
But then, is there any other headman issued by William Simship?
So far as I'm concerned, I do not have those, I do not see those.
You just approve, my Lordship will see annexure 16, page 66. This was the last letter by the Joint Secretary, Laka Administration.
Yes.
I am directed to inform you the Executive Committee so has pleased to approve the appointment of Shri as a new Sardar.
So there is no other headman, Mr. Vajirava?
As per the allegation, actually I have just received the brief recently. As per the allegation, it said that one village, the sanat was issued by the Millennium Simship, the other body.
That is where the problem
is. Same village?
Same village.
Split into two, my lord. Maulang A and Maulang B. Yes, my lord, if we may permit to file an affidavit 3 weeks.
How will it help?
We'll just prolong the matter.
Anyway, let him have 2 days time.
Yes.
This matter on Monday to enable Mr. Abdul who's entered the parent's behalf of spot number 4, brackets in William, to obtain instructions. Mr. Dingdo Sunso has also entered the parent's behalf of respondent number 5. Yes. This on Monday. You get instructions?
31.
Wait, please, Your Lordship.
Yes.
Lordship, steps have been taken by the petitioner, my lord. And
Yes. They've received 1 and 2.
Lordship.
Not received back. Yes. You are appearing in person?
In person,
On behalf of the Chief Information Commissioner.
Yes.
I'm the Secretary of the Commission.
Why are you appearing in person? You don't have a counsel?
We are yet to send to the
What is your
government.
name? Your name?
My name is D. Power. D. Dorina Power.
Okay. Yes. And this number 2?
Number 2 is
Hiranmoy Datta.
responding by.
Yes, I just take down on behalf of respondent number 1, MSD Power. You're an MCS officer.
Yes.
You're serving as MCS, serving as the secretary.
Secretary.
To the Chief Information Commissioner. Is present in court today. Submits that he yet to engage a counsel. Service report on behalf of number 2 is not complete. This is a matter after 1 week for you engage a counsel and for appearance of for service reports for number 2 and for further orders.
My lord, the interim order may continue.
Interim orders will continue till next date. Yes.
Evening.
Hearing, item 32.
If this matter can be listed at the end of the board, Lordship.
Listed at the end of the board or taken up at the end of the board?
I mean, taken up after in
we
the
pass order, nothing else to be heard.
My lord, in this case, my lord.
Lordship, my senior is on legs before the division bench, Lordship. He'll be coming to appear, Lordship. Lordship, this matter can be taken up at the
My
end
lord,
of the board.
basically now, my lord, it is a matter of disposal, my lord, because from my submission is that this case, they have gone beyond the
senior
scope
has
of the writ petition,
some
because the
submission to
challenge
make,
is
Lordship.
regarding the interim managing committee.
Then why have you gone and threatened those villagers waiving the report?
Lordship, my senior would answer that.
How much cost you'll pay to the village?
Lordship, Lordship, I have no idea, Lordship, about that.
Now for the village cases, we'll fix costs by like 5 pigs, 2 cows like that, instead of giving costs in terms of money. But if you don't have money,
let this matter be called
5
at the end of
chickens
the board,
through it'll be more appropriate. It'll be more appropriate because if you don't have money to pay costs. Yes.
End of the board, Lordship.
38.
See, this matter was already heard on last.
I don't remember anything. Yes.
Regarding the Afroza, she filed a petitions claiming the salary that she was not paid the salary.
Why? How come he said you're not unavailable? Now you're here. Where's the junior? Other kids want to dispose of regarding that Islamia school.
She's new.
He says not available. How long you practice?
Very recently.
3 months, Your Lordship.
3 months. You're very good for 3 months, but you should have called him before you dispose of the matter of. Yes.
Lordship, may recollect this case whether I filed these writ petitions for the salary, which I was not paid by the school managing committee June 21. They have stopped paying salary from June 2021. Then they filed petitions, affidavit in opposition they filed. They said the appointment is fictitious. Then court said to take actions. The government shall not take actions. Let the managing committee take. Managing committee say I cannot take any actions. The matter ends. Afterward, now I file a rejoinder just to show that I am the teachers sanctioned teacher. Because usually there are 3 posts only. I am the sanctioned teachers, but one of the managing committee where the person Tosufuddin claiming to be headmaster, he's the one who is creating a problem. The person responsible for stopping my salary.
One second. Who is appearing with Tosufuddin? You're appearing.
He has not been implemented as party.
But he's the secretary of the managing committee is creating a problem.
I am representing.
Why we didn't plead the...
No, not necessary because he's the secretary.
But he's a teacher competing for your post, correct?
No.
Then?
He is depriving me because
who's the post where you want to hold or you're holding or you want or I don't know whatever. Like who's holding it now?
The post we do not know, because as per the approval order.
How do you expect the court to come to any?
His name is nowhere. I do not know how he is stopping my salary.
My lord,
How is stopping your salary?
Because he's exercising his power as a secretary, and he's not releasing my salary only.
my lord,
What is your? Are you a teacher at school?
yes, your lord.
But then he said you nobody.
My lord, she was teacher in the school, not SSS teacher. She was there in the school, and she was getting the salary. But since June 2019, she has not been attending the school.
No, that is a different
and
issue.
He is claiming salary from under the scheme of SSA. She is not
The
entitled for that.
core issue in this case that they're saying that I am not the sanctioned teacher at all. But as per the writ petition which I filed, page 14, annexure 4, it clearly shows that one Sri Afzal Haq is headmaster, social studies teacher, Nasima Mumtaz, science teacher, myself, petitioner Afroza Khatun, language teacher.
And the state's helping whom?
The state should be neutral, but the state is filing a contradictory affidavit from different officers only. For that reason, Lordship, what we feel, suppose if the matter is investigated by district mission coordinators, because claim,
it is only for allegation.
because one officer said given RTI in my favor, then the government brought another RTI, other party, this in their favor. I do not know who is the proper authority to give the RTI.
Only the thing is that, my lord, because he is not in the present in the school since, according to us, May 2021 to till date, because a spot inquiry was made by the DSEO. Then he is found absent. He is not attending the schools.
He or she?
She.
If that is
So
the case,
that is the reason she is not entitled for any salary.
So then, Lordship, that is a different
Since
case.
2-3
Now,
years.
then you admit it, if they admit it that I am a sanctioned teacher and I am prevented by the secretary not allowing to go to the school. That is my allegations. Once they admit me that I am a sanctioned teacher, the matter gets resolved.
Whether sanctioned or non-sanctioned, he must be present in the school, continue in the school. He must render his service. When he is not in the service, committee has already terminated
That is my
her.
specific pleading in my rejoinder that after Tosafuddin became a secretary, he stopped my salary, he preventing me from even doing my duty also.
It is mere allegation, my lord. There is no record that prevent.
But the issue is that whether I am a sanctioned teacher or not, that is the only issue here. If I am a sanctioned teacher, the government should understand that. Only the sanctioned teacher is entitled to get the salary, not any other persons.
There is only 3 sanctioned teachers, my lord.
So I am showing
So all the 3 are getting their salary directly remitted from the DSEO office, my lord, at present. So she is not entitled for any salary.
No. How the government should be neutral in this case?
No, we are
But
neutral
government is
because
directly
after
supporting
inquiry
the
it is
Tosafuddin.
found that this petitioner was absent from duty.
What the person not teaching also?
No, he is the teacher. He
What
is for social
about then? What about this letter dated 8/3/2017?
Yes. His approval was already there since
And
2017.
provisional approval of Sri Tawfiquddin Ahmed should not affect from the issue of cancellation order. Don't understand what it says. How many affidavits have been filed here? 9 affidavits.
Yes, the government has filed many affidavits.
2-3 affidavits.
The government filed 1, 2, 3, 4 affidavits. Government filed.
Consolidated affidavit has been filed by the government lastly.
That is not the consolidated affidavit.
Consolidated affidavit
That is
filed
not
by
the
this
consolidated
as per the honorable court order, my lord.
Consolidated means you cannot bring the new facts on that. But
No, there is no
again
new
they
fact.
brought in new facts in the case.
Nothing new fact, my lord.
Yes, we have really sustained confusing this court.
Yes. So, Lordship, in this case, suppose if the district district mission coordinator may be directed to make an inquiry and submit the report to the court. I think in that way the matter can get resolved.
To show that there are materials.
No,
that
because
warrant such an inquiry,
because,
or your claims based on some, based on some facts or something.
No,
but if they say that you've not been working 2019,
Lordship,
and just coming here an empty claim for your back salary without being a sanctioned teacher,
Yes,
does that call for an
Lordship,
inquiry
in
to be
this
done
case,
by the sub-divisional education officer?
From June, before June 2021, I was there in the school as a sanctioned teacher. This is the month of June 2021. They have stopped the salary. Because after Tosubuddin become a secretary, he is doing. Now, if I am not permitted to go to the school, the core issue here, Lordship, is whether I am a sanctioned teacher or not. If that is resolved, if they say I am a sanctioned teacher and I am not...
Fine, let's go to your initial appointment order. Everything starts from there. Where's the initial appointment order?
Initial appointment order, Lordship.
Whatever rights you have emanate from there only, yes. Where is it?
Lordship, because the government is releasing the salary, that's why is important.
No,
Page 14.
Yes.
Page 14 is the page 14, Lordship, is there. In continuation of this so-and-so, this is the order passed. This is the basis. Here it clearly shows that it was issued on 18/9/2018. Afzal Haq, Nashima Mumtaz, and these are the 3 sanctioned teachers.
Okay. And from there, next what happened?
Thereafter, because earlier also they did to me, then I went to the High Court, and High Court passed an order.
Earlier they did what to you?
Earlier page 5, Annexure 5, page 15. Because if the case if I start case...
No, what happened? You lost your job.
No, I didn't. In that time, as per the page 15, Annexure 5, they have my salary was stopped. I came before the Honorable High Court, and the order was passed on 3/12/2018, whereby they are directed to release the salary. They did not do. Then I filed contempt of court. Then they start releasing the salary from 2018. 2018.
Yeah, what happened after that?
2018, I was getting a salary. I was discharging my duty in the school.
So this is the only appointment order. This only order. They are the SSA teacher.
Yes, that is the appointment order. Thereafter, Lordship.
What is this? Issue 3. You remember the managing committee also?
Yes, I was a member of the managing committee also. I was a member of the managing committee also. Now, in this case, thereafter, my simple prayer only one prayer in this case, not a multiple prayer, only prayer that the salary from 2021, June 2021, be released.
Who's eating his salary now?
That's what we do not know, because it is credited to the account of the managing committee, and the duty of the managing committee
now
is disbursed.
The account sanction teachers only. It
Yes.
doesn't go to managing committee anymore. Correct, Mr. Hazarika?
Now maybe, I do not know who is eating my salary. I have no idea about this, because in the RTI also they have not said anything. Now the government, the first affidavit filed by the government.
Okay, now understood. Now you appointed and consider, is this letter fake or real? Or is it true copy? Otherwise, from there always a lot of fraudulent letters.
Can you see that there is an order passed by this court only? When they had taken the plea, first the private respondent had taken the plea before the court in their affidavit that the approval order passed by the school, that is our approval, is a fake. Then court asked question, I think the order is there already in the order sheet, what action you have taken? Then he said, I'll take instruction.
Oh, so this order is fake.
We have said in our affidavit, Your Honor, this.
Then did you file FIR?
No.
Then?
By not taking action does not mean that it will become genuine.
By not taking action shows that you accept it as genuine.
You see, we have
We can take it any other. We can take it otherwise.
Terminated from the school.
We have
Terminated her from the school. We have issued the notice, focus notice also, and thereafter we terminated.
That is a different ground now they are taking.
Then will this school send forensics? Where's the original order?
This is the order, Lordship.
Original.
Original
by the petitioner.
Of the department. No, Lordship may see the Lordship if Lordship may permit, because this case was heard many occasions, and the case was delayed because of the reason it was that The private respondent said, we'll take action. Court has given time. You take action within such a period. Afterward, they came here. They said, no, we cannot take action. It is the government who will take action. Then the court again passed an order, government to take action. The government again said, no, it is I cannot take action. It is the managing committee who will take an action. Because of the reason the case was delayed. Ultimately, now they are not on the forgery. They are not on the sanctioned teacher. They are simply taking a plea lastly, saying since he is not appearing in the school, not coming to the school, that he is not entitled.
You're running around in circles, yes.
Now,
where's the order saying for why, asking them why they have not taken action?
Is there, Lordship? If I...
My God. Yes. 24/6/2022. Over 2 years. Which affidavit, who said it's fake? You said.
I have also said, they have also said in the...
No, my lord, I will come to our affidavit.
Okay,
The
you highlight
affidavit.
the orders where this court has said that, no action taken. We'll have it next, when today is?
11. This point is clear in my...
On 19th, you just flag it. Flag it instead of running around in circles like this, not serving any purpose, then we'll take action. Yes.
My affidavit is clear, all these points.
Yes, clear, but then you fill 10 affidavit you file. How can the court go through all that now? At least you come, you just come write a small note. In this affidavit, this paragraph, this has been said. And this order, so and so, court has directed action be taken, and you have not taken any action. Both of you also.
It is there, my lord.
Applies all of you.
It is there, my lord.
42.
You give your points, it applies all of you. Otherwise, we can't just keep on swimming like this. Yes. Yes.
This clause is an election petition, my lords. It's on the 7-11 stage, the stage of where we have filed an application for rejection of the election petition. Primarily, my lords, the grounds which have been urged in this case are one in respect of presentation of the election petition. The other very important ground which emanates out of this matter is in respect of compliance of section 81(3) of the Representation of People's Act.
1 second, just give me 5 minutes. Huh?
Yeah.
Just come back. Someone. Yes, what do you say?
Yes, my lords. So, in this matter, my lords, an application has been preferred under Section 86 of the Representation of People's Act. Primarily, my lords, the ground that we have raised in this case
No,
is...
one thing, see, before you begin,
Yes.
Mr. Deb has said that this is covered by the early judgment of this court,
Yes.
but you have deferred.
Yes.
So what are the points of difference that you
I'll focus, my lords, on those points of difference only, because your lordships have already decided those matters as far as presentation is concerned, and to a large extent, my lords, those determinations as far as presentation would apply in this case as well. So presentation has to go to the course of evidence, and to that extent, my lords, I am not quarreling with that proposition.
Then why? Then what is your issue?
Well, the issue of difference in this case is regarding compliance of Section 81(3). Presentation is in subclause 1, and my emphasis is on 81(3). If your lordships kindly have 81(3) first.
Yes.
It says, my lords, every petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition. And now it's a very important, I am placing emphasis on this part. Every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. So I will demonstrate as to the second part of Section 81(3), which says that attestation by the petitioner that it's a true copy has not been complied with in this case.
Yes. Yes.
Straight away, my lords, I'll just highlight the relevant part of my application where I have made this submission, then his reply and my replication.
This is EP 2028.
Yes, my lords.
Yes. Your replication.
Yes, my lords. Replication.
Yes. Page.
Yes, my lords. My lords, may I kindly have page number 26, para 19. Replication. 26 of my application.
26. Okay. Yes. Page.
Yes, my lords. Para 19, my lords, the heading is election petition is liable to be dismissed as true copies have not been. Now it says that it is submitted that the present petition is liable to be dismissed inasmuch as the true copy of the election petition.
This is replication filed on 5th February
26 of the application,
huh?
26
I am
of the
or
application.
26, my lords, I am sorry, 26 of my application. Of my application.
7-11.
Of 7-11.
You said replication, that's right. Okay, para 19.
Para 19, my lords, where I have made a amendment regarding the non-compliance of 81(3).
Yes.
It says that it is submitted that the present petition is liable to be dismissed inasmuch as true copies of the election petition attested by the petitioner under the signature of the petitioner was not served to the answering respondent. It is submitted that Section 81(3) of the RPA 1951 provides that every copy of the election petition must be signed by the election petitioner with the attestation that the same is true copy of the election petition. It is submitted that this provision is not complied by the election petitioner and the same is a ground for rejection. 20. It is submitted that none of the pages and I will demonstrate, my lords, in a moment from the copy of the election petition served upon me. None of the pages of the copy of the petition served to the answering respondent is signed to be true copy of the election petition. It is accordingly submitted that the election petition is filed in violation of 81(3). My lords, now I will, my lords, with your lordship's permission, supply the copy of the petition served upon
you.
Yes.
Yes. Not signed every page.
My lords, nothing is signed in this petition which has been served upon me. And my lords may just see. First page, the index, nothing is there. Synopsis not signed. No date is mentioned. Page number 6, the list of dates.
You agree to this? This is the copy you served on them?
I don't have a copy of it because the one they have enclosed in their application does not have those.
No, I mean, look at this. If this is the copy you served on them, it's not even signed. Even the page one is not signed. Even who's filed it, or there's no signature of the election petitioner.
Also, because at the time of presentation, we were not the council, so the one they have mentioned in their application as the certified copy of the election petition to be obtained by the answering respondent is jury. But there is no.
They must be aware because they are the one who are serving upon me.
With regard to the whether that was the copy that was actually served or not, that I'm not aware, Lordship.
No, but can you take that? No, but it's just see. This is a copy given by them. That this is the copy given, served on them.
Lordship, the copy which they have appended in their application, stating to be the copy that was served upon them, bears the signature, Lordship, in each page. Kindly have
the
page
copy
23.
that is served, I'll just correct my learned.
This is the copy that is served on you.
This has been served. The copy which is annexed with my replication is a certified copy obtained from the court, just to show the difference.
In your replication or
in my replication, I have also annexed a certified copy from the court. So
your endeavor now is to cut short the entire thing here only.
Yes,
without the necessity of going for evidence.
Yes, my lords.
Yes. What do you mean grounds of challenge for the thing? On affidavit, subsisting contracts.
Subsisting contracts.
The first requirement is to file a proper petition.
The issue
it's become learning experience for the lawyers here, because in the beginning when we matched, I said that remember it's very technical and you have you have to look at it with under a microscope.
Lordship.
That's how you file election petitions. Yes.
Lordship, if that copy can be.
You can have my copy. You can have my copy. This is the notice which has been served. The petition starts. The affidavit has not been signed. There is no notary there. Nothing, no page is attested to be a true copy. No signatures are there. So how come, my lords, I can take it to be a copy which has been filed with the court?
No, the requirement of law.
Yes.
That should be attested in every page copies. Go to what record?
This, because
in the replication.
Yes, kindly see.
What have they annexed? You have annexed what page is it?
Yes, my lords, I have annexed a certified copy from page 23, and your lordship can see. Page 20. Yes, my lords.
Of course, the
notarized by
is not there, but the signature is there.
Notarized by Miss Melorica Lingua, and it is signed.
Signature of the it appears in every page.
Yes, my lord.
No, but if you have not you just see 81(3) again.
Yes,
I understand, Lordship, because the copy which was
it's. These are the copies you give to the registry, correct, for service.
Frankly, Lordship, at this point I am not in a position to ascertain that, Lordship.
No, you see, the thing is that together with your first copy that you filed, as many copies which you file before the registry, they also have to be
true copies
attested.
Of
yes,
Lordship,
true copies. Yes.
Lordship, in my humble submission, that was so done, but it appears, Lordship, since he has produced it.
No, I mean, you took steps through which method then? Because You just see the order sheet.
I'm also little, Lordship.
You're swimming.
Because at the time of presentation we were not the counsel. I don't know whether which was the actual copy.
You
which
can
was
have,
served.
because I have a e-copy, so I can use that.
So it appears, Lordship, notice.
Yes,
was
you
issued
took
through the
steps through registry AD,
registry,
yes.
registry
On 18/4.
on 18/4, Lordship.
So these are copies you filed before court. So Mr. Dev, I'm sorry, your election petition has met a roadblock.
Lordship, let me just go through the record, Lordship, once, try to get a clear picture of this. If required, Lordship, I just try to.
Oh, you
contact
see,
with
what
the
happened was the
counsel.
dusty service was taken on respondent number 3. Yes, respondent number 3.
Lordship.
Who's respondent number 3?
He's the.
I am respondent number 3. Yes. Because, yes, Manoj, I am respondent number 3, and the first 2 respondents have thereafter been
So
removed.
what happened? It has been returned. Manila envelope. Who's Shantanu Singh? Who's Shantanu Singh?
He was the original.
Where is he from?
He's from Delhi, Lordship. Thereafter, he has lost.
Yes, for about 5 months, all dates were adjourned at the request of Mr. Singh. So,
This another item number.
Not taken, steps not taken, 24, 5 steps not taken. Then, how did you receive the copy? Then on 3rd of July, you entered appearance last year.
yes, Manoj.
How was notice served on you? By personal service or by from the court?
The local councils may be in a better position.
Or copies was given over to
the council.
the council?
Through registered.
Now what happened?
Okay.
What happened to the copies you filed for the court?
Lordship, it was taken steps to registry, Lordship. In the statement.
No. Again, later on, Mr. A. Joshi praised well to take dusty service also.
So, my friend is indicating towards the notice which is at the first page, which has been issued by the registry of this.
This was received by you?
Yes.
Through the registry?
Yes, this is my instructions are there.
If I may, Lordship, because
Does it have a breeder?
Some confusion is there. If I may just go through the entire record in the order sheets, Lordship, just to see how the steps was taken and how it was.
On the objections, obviously, as Pandit Council for the
applicant,
respondent number 3, that the election petition does not meet the requirements of section 81(3). Mr. S. Deb praised that we allowed to go through the records in the registry to ascertain this fact. Yes. When you want it listed?
2 weeks, Lordship. I'll try to get it.
But you verify whether he's still interested, because all these election petitions which are pending here, they are suffering from defects which is not the fault of the election petitioner, but it's been caused by the
lack
of ignorance with the negligence of counsel.
Yes, only one thing, Manoj, the first 2 respondents being the chief election
They've been struck off.
They've been struck.
Yes, that is all for the case.
45.
Obliged.
45.
Obliged.
Well, if that's the case, then
Manoj, it cannot survive.
With regard to the compliance of section 81(3), Lordship has otherwise decided in another matter.
No, that's different.
First,
that's
the issue
different.
of presentation, thereafter the question of
Presentations on these dispute on the facts. See, it's not on records. Presentation, why evidence records? Because they said I was here. Some fellow said I was in the canteen, or I had come for notary and so date. I had come before this person. Then that will call that person, say, did he come before you? That's all. That's very to ascertain just that.
I understand.
That's why it's a preliminary thing. But out here it's totally on records. So if you can't satisfy that, then you.
I understand, Lordship.
Obliged.
Your Lordship.
Yes.
Your Lordship, I pray that this matter may come up day after tomorrow, Your Lordship. As
The only thing, own instructions, whether you have not received instructions.
Your Lordship, actually, Dr. N. Musica is on legs before.
Whatever it is, whether it's been retendered or not.
Your Lordship, instructions are not with me, it's with Dr. Musica, Your Lordship.
Came on 6. 6 is still too short. Yes, solicitors matter on, it's been retendered.
Retendered.
Who are you?
I am executive engineer.
Come forward.
Retendered done. Yeah, that's all.
And completed.
What? This is started.
He's the one who passed the order.
You are, you're the garrison engineer, or what's your post?
Yes, executive engineer.
Executive engineer, BSF.
Yes, sir.
Your name?
Name is Tapas Pramanik.
Tapas Praman.
Yeah.
Mr. Tapas Praman, who is present, who is the executive engineer?
Sir.
What is the designation? Executive engineer?
Deputy Commandant Works.
Executive engineer, deputy commandant.
Works. Equivalent to the.
Your designation is deputy commandant.
Deputy Commandant Works.
Yes. Which circle?
Meghalaya.
Meghalaya. BSF.
Yes, sir.
Is present personally today in court and submits that the work has since been tendered and has and the work has and the work is also commenced. As the learned TSC will presently, this is the matter we'll have it on Monday. Here's the matter on this. Monday is 18.
18.
Right.
Yes.
47.
Your Lordship, I pray for 2 weeks' time for not being well.
Not well?
Not well.
What happened to you?
I got fever now and high BP.
Then you're sitting in court from the morning. Why didn't you adjourn it then when everyone's mentioning the cases? You missed the bus?
Yes, Your Lordship.
Amit Tigeta submits that the matter be adjourned for 2 weeks as he's not feeling well.
Yes.
Police for 2 weeks.
Obliged, Lordship.
Obliged.
Second call. Item 32.
My Lord, with Lordship permission, we have perused the inquiry report submitted by the inquiry committee. I just point out, my Lord, a few things. Now, they have stated that, my Lord.
No, but Mr. Changreso, is it true that he's engaging all these subversive activities, going and threatening the villagers, those who have put names on there?
Absolutely nothing. That is very unfortunate. Very unfortunate. Nothing is there such. He's an aged, elderly person in the village. He never goes to trouble.
But the reports are saying that,
in my
by the
absence
government
earlier,
advocate.
in my absence that submission was advanced, it is nothing as such happening in the village. I'll just point out the 14 persons, elderly person has given a statement to the inquiry committee. On that basis, my Lord, they have given this report saying that school is never handed over to the petitioner. Out of 14, my Lord. Then after, my Lord, the inquiry was conducted on 2nd May. Now, all the 9 statements given by the elders, it was authored on 3rd, 4th May, after the inquiry, and they received on 2nd May. And another witness, he authored on 16th April, where even Lordship had to pass an order for conducting inquiry. I'll just show a few. Accordingly, my Lordship may pass necessary order. I want to please bring to your Lordship notice. It's a very serious matter. They have the audacity to file this false material before my Lord. My Lord,
false inquiry report?
Oh, yeah, my Lord, I'll show my Lord. Please, Lordship, may kindly come to page 11 of the inquiry. Page 7. Page number 7. Point number 6, handing over of school.
They file a suit then.
I'll give Lordship permission. Now they have mentioned, these are the names, 14 of them. 14 of them. Now, I may come to the annexure, my lord, annexure 14 of the inquiry. Pagination was not there, but annexure 14, lordship.
Annexure 14.
Annexure 14, madam. Statement of there was an elderly person who came forward as a witness or deposed before the inquiry committee. You should have given the page number. Page number is not given.
Yes.
My lord, annexure 14. Now, this is a statement, author on 4th May.
Where's written?
Yes, on the
4,
top.
5 on top.
Yes. Inquiry was conducted on 2nd May, my lord. And they received on...
Dates enter subsequently.
And the date of the receipt by the STSO at the bottom, 2nd May.
No, this is just a thing. It's just enter.
My lord, there is subsequent submission of the statement, my lord. Inquiry was physically conducted on the 2nd of May.
I'll just point out.
Yes.
This is this one, and second one also the next page.
The second 5.
But the author, my lord, the author on 4th May. They
Where
receive
4th
on
May written?
at the bottom, my lord, 4th May. And they receive on 2nd May.
How is it possible to write in a letter if it's not existing? How is it possible if someone write on a letter if it doesn't exist on that date?
My lord, therefore, it is absolutely
Not
wrong.
a mistake by this poor old man.
It cannot be. The two inquiry officers were there.
No, whatever it is, I mean that this entry of this date, the writing also see. Now it's just received. Receive on. Why should he put a wrong date? This SDSEO.
My lord, if the party submit on 4th or 5th, he would record I receive
This
on
is
4th.
whether. See, this is 4th or 5th. Maybe they've written the wrong date because this all receive on 2nd.
My lord, the next page, kindly see the correct one. Author on 2nd May. My lord, they receive on 2nd May. That is, we understand. On the day of inquiry, author himself, we don't know, my lord, they came.
This also on
and the next
even
one.
The next page, so 4th May.
4th May,
given wrong dates only.
My lord.
There's also next one also.
Next one is the 4th.
3rd May, and it's all 2nd.
And another one, lordship, go further.
You mean to say that they were written? They'll make such a glaring kind of even the 16/4.
16/4, my lord. That is much before the inquiry. But the next one will say 3rd May.
I don't think that. Why should they make the mistake? Why should they receive on 2nd then?
Therefore, my lord, the inquiry was concluded on 2nd May, according to the version of the inquiry officer. And the other people.
You get instruction in this part. Like when was the receipt? Why was it stamped on 2nd? That's all. I don't feel accept the inquiry report.
That is one aspect. Other the real issue is.
At the time disposal of the incident matter, let's say the council has referred to certain documents appearing in Annexure 14 and submits that though they seem to have been recorded on 4/5/2024, the seal or receipt of the same is 2/5/2024. You can get instructions.
My lord, I'll try. My lord, Mr. Bunn can also help because if those are because he can also inquire what was the date of submission and.
No, we're wrong with the given. Why should they see? It stands to see why should a sub-divisional officer or the SDSEO write the wrong
my
date?
understanding, if there are 2 dates, one date is basically the date of the inquiry, and subsequently they've given 2 dates because we cannot go beyond the 2nd.
No, why? How is received on 2nd? How is it received on 2nd in the file? See, 2nd 5. If the date 3/5.
No, my lord, 2nd, they are relying. They're relying on the 2nd of May, probably because it was the inquiry date. This inquiry was verbally concluded on 2nd May, and subsequently some of them has given in writing.
After that.
So, my lord, there is no contradiction in my understanding, my lord, because one date is the physical inquiry date, my lord.
Otherwise, Mr. Shangriso, you advise a person also. He's retired. Just tell him to relax. So. He has obtained instruction. We'll close it.
The main issue, my lord, Lordship has heard them. I'll just place the egg in Lordship in person.
Yes, list after 2 weeks. Yes. We can't keep this matter pending.
Yes. Lordship has heard the matter. Second was a connected matter.
Unlisted matters, supplementary list 1, then move on.
What is this?
This is a matter, my lords, where the learned special...
From which order?
Yes.
Where's the impin order? I mean,
order, my lords, is 2910 at page 21.
Yes. This is under... After that, what? PS case?
Yes, my lords. A PS case, my lords. A case where FIR was registered on the basis of information given by the Assistant Commissioner, my lords, in July regarding certain unidentified coal which was lying. My lords, information was given thereafter police investigated that matter. Investigation resulted into a closure report because of lack of evidence. Now, the powers which are exercisable, my lords, by the special judge are under 173 of the CRPC. This is prior to the notification of the new legislation. So, now, my lords, in that, asking the Deputy Commissioner to be summoned, making observations as if the learned special judge is exercising plenary powers, my lords, of a constitutional court. The Deputy Commissioner has been summoned, the Superintendent of Police has been summoned, and divisional mining...
With regard to what?
This is, with regard to, my lords, it's not apparent from the even order as to why these officials have been summoned.
Why they've been summoned?
Yes, my lords. I will just place the order, my lords. Page 21, my lords.
Yes.
The first paragraph, my lords, is, this is a case where an FIR was filed by the extra assistant commissioner.
Okay, regarding illegal mining?
Yes, my lords.
Yes.
Alleging mining of coal at Sengtalang. The FIR was filed after concerned extra assistant commissioner Shri so-and-so had conducted inspection. The FIR is supported with photographs which appeared to have been taken through the drone. The FIR is registered so-and-so case under section 21(5) of the MMDR Act.
Yes.
The investigation, para 2, culminated into FR number 5 of 2024.
Yes.
The OC, PR Marak, is praying for closure of the case due to lack of evidence.
Yes.
This court had observed in order dated 24/11/2023, when the FIR was placed before the court, that the district administration swung into action only when there was reporting in the newspaper showing that illegal coal mining activities is continuing in West Jaintia Hills district, and the report was based on the interim report submitted by Justice Kataki. Para 3, my lords, the court had issued notice to the informant before passing any order. The informant, Mr. So-and-so, has appeared before this court, who is none other than Meghalaya Civil Services, posted at Amlaram. On careful perusal of the final report, it is found that the investigating agency focused more on the auction of the coal, and finally the coal was auctioned. However, till date the coal has not been lifted in spite of the coal being auctioned. The informant so-and-so, who is present before this court, on being asked by this court if he has any objection to the final report being accepted by this court, stated that he requests instruction from the Deputy Commissioner, who is his superior. On further being asked by the court why he requires instruction from the Deputy Commissioner, the concerned officer very boldly stated that he has no answer. This court is constrained to observe that in spite of umpteen number of orders passed by the High Court, Supreme Court, NGT banning coal mining, the activities of illegal mining appears to have been going on, which is an irrelevant consideration for 173. 6. The court would not like to make any observations at this stage on the manner in which the investigation was carried out, it appears that the inspection was conducted before filing of the FIR. There is no whisper of the inspection in the final report. Now, my lords, the Deputy Commissioner shall appear before this court in person. Inasmuch as the informant has categorically stated that he requires instruction from the Deputy Commissioner, this court is very curious to know as to what kind of instruction is required in illegal coal mining. 10 days' time is given to the informant to file objections, if any, failing which this court shall pass necessary orders. The Superintendent of Police, Deputy Commissioner, IO and the informant shall be present before this court. Needless to say, if they fail to appear, necessary orders shall follow. Thereafter, my lord, goes into para 8. This court finds that the coal seized in the instant case has been auctioned by the Deputy Commissioner, West Jaintia Hills, on 9/6/2024. The successful bidder, Mr. So-and-so, has not lifted the coal till date. Now, further direction, my lords, in para 9, the Deputy Commissioner shall ensure that successful bidder, Shri So-and-so, appear before this court to explain why he has not lifted the coal till date. The District Mining Officer shall also appear before this court. Copy of the final report shall be supplied, fixed on, my lords, 13/11 for filing of objection and appearance. So, my lords, in my humble submission, my lords, there is no occasion for the learned special judge to, my lords, exercise these powers of summoning the officials. His, my lords, powers are circumscribed by the Code of Criminal Procedure. On filing of a closure report, he can seek objections from the informant. If the objections are satisfactory, he can demand for a further investigation. But calling all officials, my lords, and Supreme Court, my lords, has categorically, my lords, even as recently in 2024, has laid down standard operating procedures that on drop of a hat you cannot summon these officials. Because all those things have not been my lords, not taken into consideration, and the orders have been passed as if the learned special judge is exercising plenary powers, my lords. So, my lords, this is a very strange case in that sense, and I may place, my lords, one judgment, recent judgment of the Supreme Court.
No, another thing is that only one thing.
Yes, ma'am.
The special judge is with regard to the MMDR Act only.
Yes.
Where is that? Where is that? Don't we annex it here? Because these special judges are appointed.
Well, that is under Section 23 of the MMDR Act.
Yes.
If your Lordship has the MMDR Act, then I can place that provision. I have that.
No, because these what's happened is that in every district they are designated after this illegal mining thing.
Yes.
That with regarding Zimma, with regarding to all this. Which section?
It's 21.
No, it's not. What's in? No, investing these courted powers. Where's that?
Yes, but it's 23, I believe. Just a moment.
No, it's also the company is 23. Yes, it'll be in. Second, power state government where? Yes, 30C.
30C.
They mean the vested powers under 30C.
Yes.
Correct, Mr. Shulai?
Lordship, yes.
You're not aware of it?
Yes, my lord. Special courts to have powers of
It's
court
under
of
30,
session.
under section 30C, yes.
Yes, my lord.
Yes.
There is a special power, that is why he has been conferred, Your Lordship.
No. Where's the notification? Because they've been invested specially, or are they invested by name or by office?
Lordship, I think it's by name or by office only, Your Lordship. I don't have that notification, Your Lordship.
Yes, because he's acting is under 30C. You see, it's a power to, so 30C. Yes, what do you have to say?
May it please Your Lordship. Lordship, so far the direction to the officer to physically appear, Your Lordship. In my humble and respectful submission, Your Lordship, once a final report has been filed, Your Lordship, by the investigating officer, Your Lordship, under 173 of the CRPC, Your Lordship, if the presiding officer is not happy with the closure report or the
they can direct for
Lordship, yes. There is a section under 173(4), Your Lordship. He may direct for further investigation.
Yes.
Or Your Lordship, there is another option under section 190, Your Lordship, of this RPC. He may refuse to take cognizance on his own, Your Lordship. Lordship, kindly come to 173(4). May I read it, Your Lordship?
Yes.
Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under section so has been forwarded to the magistrate.
Where are you reading from?
Lordship, I am reading, Lordship, from 173(8), Your Lordship, not 4, I'm sorry,
Yes.
Your Lordship. 173(8), subsection 8, Your Lordship. Larry's special judge, Your Lordship, to be fair, could have taken recourse to section 173(8), Your Lordship, right with section 190.
No, but what's that investigate here? Because as per the findings, it's been auctioned.
Yes,
and you asked the person to appear also to why not lifted. But is it within the purview or in these proceedings to ask for the person why is not lifted the auction call?
Lordship,
been past the full bench like those people have been lifted.
I don't think, Your Lordship, that power is there with the learned special judge.
To the state. No.
I don't think that power is there, Your Lordship, with the learned special judge. Calling for personal appearance or...
No, not that. We're not talking about personal appearance. We're talking about, see, this is a peculiar situation.
Lordship.
Now, what has happened is that orders by the committees, they're constituted, and the orders come in a form, reports come to the full bench.
Lordship,
right?
yes, correct.
A special bench. The special bench directs, okay, fine, like what to do in cases of where the coal is not lifted, or what should happen in that instance. Like whether the coal is forfeited, the reserve amount paid is forfeited, and the coal reverts to the state to be auctioned to one else, or what steps take. Whether that's within the purview of the special judge. That's what this court wants to know. Like whether he has the latitude over and above whatever 173 prescribes. Suppose the coal has been auctioned, is not lifted. What happens?
See, by humble submission,
I think
subject
Lordship.
to correction, my lords, in my humble submission, as far as lifting of the coal is concerned, because your lordships in the suo motu matter.
Exactly, I'm concerned about that. You're concerned about that, yes.
Is already session with that issue, and if necessary orders have to be passed in respect of lifting of the coal, that has to come from this honorable court.
No. That's why there's a blanket order that's saying that those people who have not lifted the auction coal within a certain period, that coal stands forfeited. Where these orders are there? There's so many orders that,
Yes,
we know that we pass those orders, but it doesn't come to mind right now.
Yes, my lords. But here, my lords, the learned, what is the remit of learned special judge inquiry?
Who's appearing suo motu matter? Advocate General.
Yes, my lords. Advocate.
We'll take it up at 2. You kindly just get those orders, yes.
Yes.
With a special judge, in other cases.
Yes,
Lordship, appears, Lordship, if Lordship kindly come back to paragraph 2 of that impugned order at page 21. It appears, Lordship, there is an FIR And there was
right. FIR
there was
with
an
regard to illegal
investigation.
coal. Fine.
Lordship.
With regard to illegal coal, that there's some illegal coal, but that's 23. So after that, what's been found is that coal's already been auctioned, has not been lifted. Now this order is concerned that the deputy commissioner should ensure successfully appear for his court explain why he has not lifted auction coal till date. Now whether it comes in purview or not, or whether it's covered by also of the special bench that says if he doesn't lift it to a certain date, like he forfeits the thing. Whether this court has, this district session judge
Special
also
judge,
has the power to pass sweeping orders, like appear before the court, ask the person to appear why he's not lifted auction coal.
Yes,
Or is it is passed with another objective in mind?
Because the special court.
That is what I don't know the powers. Whether that's something.
Lordship, my humble understanding of this order is there is an FIR filed, Your Lordship.
No, fine.
Lordship.
But see, we are not talking about a simple FR being filed in a simple matter.
Lordship,
We're talking about matter whether, in view of the proceeding before a special bench, whether as a special court he is he can pass such directions. That's the only thing. Because even the FR, there's no question.
This is a closure report, Your Lordship. A closure report submitted by the police when they are stating that there is no evidence, Your Lordship.
Of course, no.
There is no evidence, Your Lordship.
The thing is that, Mr. Shulai, this is a case which is going only one-sided. You understand? So the court has to take up, to take a balanced approach. So just look at the orders. We just try to see the orders regarding the auction coal. What happens when it's not lifted? There's only that part. And whether court doesn't think he has the power, but just for general satisfaction. Next. Yes.
Apply, Your Lordship.
At 2. Yes, Mr. Shulai. What orders?
There is a notification.
That's the only yes concern.
There is a notification that has been reflected in the order.
Yes. Let's see that. We must be careful. That is, but whether the order is necessary at all, we pass by the
Lordship. This is the order 12-4.
Last year.
Lordship, yes. Regarding that constitution of the special court, Your Lordship. And there, to that effect also, there is a notification, Your Lordship. Where is that notification?
No. Regarding that, what happens to the auction call?
Lordship, then there is another order, Your Lordship. That is the order dated 14/3/2024.
Yes.
Lordship. 43, give me 43. If Lordship kindly come to para 3 of that order.
No, regarding the auction call. See, the only thing is court concerned about is whether the auction call, where there are some orders from the special bench, that when the auction call has been lifted, what happens to it? Whether it's forfeited and reverts back to the state for,
Well, in fact, if your Lordship sees because your Lordships have passed an order that if they are not lifting it, then ultimately the state will
revert back. Where's the order?
Back to the. I'll just place that order, Manoj.
Lordship, that is the order dated 9/2/24, Your Lordship.
Yes.
I have the copy.
See, so whether it's necessary at all for the special judge to go into all this, that is the thing.
In my
just satisfy this court, because I don't want any orders to come to this bench that might be,
Yes, Manoj, absolutely.
Yes. Yes. No regard to the coal has been auctioned, not lifted. It's not regard to the coal has been reinventoried or whatever.
Yes, Manoj.
The RP General is well aware. Where is he? He's in town.
Manoj, if your Lordship sees the 14/3 order, because there are so many orders in this matter
that is why I asked you to look for it.
Yes, Manoj. The 14/3 order, Manoj, notes in paragraph 2 that the order dated 9/2/2024 has been passed for the purposes of shifting the remaining mined coal in various districts from the pitheads to the designated depots of Coal India Limited, and also for Deputy Commissioner and other authorities to issue necessary transit passes so as to enable the coal owners to participate in transportation of the mined coal. In the order, it has also been recorded that the coal owners did not show any interest in getting the transit passes in spite of public notices having been issued. According to the learned AG, the apex court in the decision of State of Meghalaya versus All Devasa has held in paragraph 195.20 that the coal extracted or mined will belong to the person concerned and the propriety right in the mineral shall not be lost. He also drew the attention of this court to paragraphs 195.23 and 25 and stated that State of Meghalaya and Coal India or both shall ensure that transportation of minerals and charges to be borne by either of them or by both, and the coal which have been seized by the state in illegal transportation and illegal mining, for which different cases have been registered by the state, has not been dealt with by the apex court in the decision. It is further made clear that State of Meghalaya shall be entitled to royalty and payment of MEPRF and taxes to pay back the balance to the owner. When the publication has been made, it is stated by the learned AG the owners have approached the state and submitted that the price of the coal has come down and they will not be in a position to shift the mineral as there will be loss to them. Justice B.P. Kataki retired has submitted the...
No, all right, Mr. Pandey. Only thing is that there's an order with regard to suppose coal has been auctioned, those people have not lifted their coal in auction.
Yes,
they've paid the reserve price. I mean, they've paid only the, whatever the...
yes, my lord.
They've only paid for the like taking part or whatever they call it, the premium price, whatever.
Yes, my lord.
But they've not paid the entire amount for lifting it.
Yes.
Now what happens, we've passed orders out there saying that will be forfeited.
Order, my lord. There is one order. I'll just, your lordship gives me a moment, I'll just indicate that as well.
You kindly get in. I should have looked at my son in the lunchtime.
No, my lords, the order is 16.5, if I have the order, 16.5, 2024 also.
It's recent, I think. It's recent. You consulted the Advocate General about this.
No, my lords, I just looked through the files and there is in fact an order which has been passed by your lordship. What the content of the order, I just went through that, but I'm not able to locate specifically the
But
order.
that is somewhere that if auction is been auctioned.
And your lordships have passed an order saying that if that is not lifted, then it will fall back to the state.
Yes, that one, that order.
Yes.
Discusses inventorized coal, inventoried coal, that is.
Please, the order dated 3/6.
3/6.
Please, when to that.
Well, that's why I have the order dated 3/6.
No, wait. CC.
3/6. Okay.
What does it say?
3/6. Very good. That's the order of 24.
Because you see, this special court has to act only in, with regard to Section 4 of the MMDR Act, and so that that's to do with also with the what's that, transportation.
Yes, my lords.
Right,
Now,
whether it extends to what has been passed, that's
my
the
lords,
only thing.
that I believe there is no, my lords, any confusion, my lords, as far as powers of the special court is concerned.
No, the excise powers they have been constituted now, especially, and these rules have been put in place, and you could exercise powers under Section 4 and 4.1A.
Yes, my lords, this is the notification of, I believe the notification is already there. Yes, please kindly circulate that.
You should have annexed it to your petition.
Yes, my lords.
Because if you are coming to 227 against, proceedings which are under this.
So, my lords, this is the notification, my lords. In exercise of powers conferred under Section 30B of the MMDR Act, the Government of Meghalaya, with concurrence of the High Court of Meghalaya, is pleased to constitute special courts in all districts for the purposes of providing speedy trial of offences for contravention of provisions of subsection 1 or subsection 1A.
That's what I was asking in the morning. Yes.
Yes, my lords. So, my lords, Section 30 of the MMDR Act does not give them any special power. Today, even the notification, my lords, is not giving any powers to the special court. And my lords, this notification was specifically noticed by your lordships in an order dated 18/10/2022.
I don't have it here. Maybe.
I'll just pull up. But if I may read that order, there's one paragraph only which is relevant of that order, and it says, my lords, in 1810. In fact, it is the order dated 12/4/2023. I apologize, 12/4/2023. And I read, my lords, the order says it is recorded that the state has relied upon.
Yes.
And a copy is also. Copy is there. Very good. Got jumbled up with so many orders, my lords.
Okay. Yes. Yes.
12/4/2023.
No. Take it back. That's all right. Yes.
Yeah.
Regarding that we don't. I just want the later order with regard to auction coal. Is it there with you?
Auction coal, my lords.
There's some order, yes, with regard to those people who don't lift the auction coal.
Yes, my lords. That is 1/5. If your lordship has that order, 1/5/2024. 1/5/2024, my lords.
No, it's not here. 1/5/24 no. 9/2/14.
I'm circulating a copy. 1/5/24. Well, that's the first paragraph itself. When the matter is taken up for hearing, the learned Advocate General produced the status report dated so and so, wherein he has drawn the attention of the court to various steps taken with regard to curbing illegal mines. So far as West Garo Hills and West Khasi Hills are concerned, actions will have to be initiated under Section 21. Insofar as Southwest Khasi Hills is concerned, the total inventorized coal is so and so, out of which so and so amount is lying outside the designated depots, and no one has come forward to claim that, and steps have been taken to seize the coal, and the same will be disposed of in accordance with Section 21 of the Act mentioned supra. Insofar as East Jaintia Hills District is concerned, till date previous hearing, a total of so and so remain to be transported, and no one has approached for issuance of transit passes, and it has been decided the government to take over the coal and transport the same. So the government will ultimately take over the coal and transport the same, and thereafter will just seize para 2.
No, you're mistaking. See, transportation of coal inventory to the designated depots to be auctioned is different. Lifting of coal, suppose owners is inventory there and they don't come to lift it or to transport it, then it reverts to the state.
Yes,
you understand? But that coal actually is to be taken to specified depots where it's auctioned.
Yes.
Now what happens when this coal is at a particular place where it's been auctioned and not lifted? That's what, there's some orders there also.
Your lordship is absolutely correct, my lords. I have also seen those orders specifically saying that the coal will then vest into the government.
Right, if they don't lift it, yes.
Yes.
Or re-auction.
But my lords, here the issue is, my humble submission.
Anyway, take down, yes. Yes, this application of 227 has been referred against an order dated 29/10/2024, passed by the special judge, bracket MMDR, close bracket, capital July, in Amlaram PS case number, what's ID? So and so. Stop. An accompanying petition has been filed, applicant has been filed, praying for dispensing with the filing thread copy, the same stay in consideration and allowed, yes, due to the urgency of the matter. Yes. The petitioners herein officials in the state of Meghalaya, namely the Deputy Commissioner, West Janta Hills, Superintendent Police, West Janta Hills, and the Assistant Commissioner Amlarem, and the Divisional Mining Officer are before this court, sealing the order dated 29/10/2024, whereby their personal appearance has been ordered on what order?
13th.
On
11/2024.
2024. Where's the order?
Order is 21, looks page 21.
Yes. Tomno? Of the said petitioners on 13/11/2024 to answer as to why where is that part?
Para 7, Milords.
Yes, Tomno? As to why can't make up.
7, Milords, 7, 9 and 10. 9 says, Deputy Commissioner shall ensure the successful bidder's answer.
Yes, to answer,
Why
to answer questions with regard to the matter pending before the court, with regard to the auction, with regard to an FIR that had been lodged, and with regard to an FIR lodged wherein a final report had been filed, and also with regard to the non-lifting of the auction code. Stop. Next paragraph. Ms. A.S. Pandey, Leonard Counsel for the petitioners, has submitted that the court of the special judge is called, right, has far exceeded its jurisdiction in as much as the matter concerns the filing of a final report by the UC Amdarem, who had prayed for closure of the case due to lack of evidence. Stop. He further submits that in terms of section 173 CRPC, the duty of the court is given therein as to how the said court should proceed. It is further submitted that though the special court which has been constituted, which has been empowered by notification dated 26 July 2022 by the state for the purpose of speedy trials of offences. Tomno, sorry for that.
It is further submitted that the special court had been empowered by the notification dated 20 July 2022.
Under section 30 capital B of the Mines and Minerals Development and Regulation Act 1957, the jurisdiction of the court was only to provide for speedy trial offences for contravention of the provisions of section 4(1), Indian 1 and 1A. Stop. It's further submitted that the appearance, the calling for a personal appearance of the petitioners is absolutely unnecessary, and the same has been deprecated in a series of judgments passed by the Supreme Court. Which would give a citation?
Well, it's 2024.
The question, the latest being
2024 3 SCC 1.
This being a case of case of whom?
State of Uttar Pradesh versus Association of Retired.
Latest being the State of Uttar Pradesh and others versus Association of Retired Supreme Court and High Court judges at Allahabad, reported in 2024 3 SCC page 1. He therefore submits that the learned special judge and acted beyond fiction the order dated 29/10/2024 will be suspended for a time being. Yes. Next paragraph. Mr. N.D. Shulai, learned AAG, has accepted notice on behalf of the Solus Pond. What's your submission?
Lordship, because as I have submitted a Lordship, this is FIR. Police has investigated. There is no evidence, so they filed a closure report, Your Lordship. If the learned special
submits that whatever procedures to be adopted by special judge should be in accordance with law as defined in the CRPC and the MMDR Act. He does. That's all. Finish next paragraph. Have heard and consulted with the petition for the parties and peruse the materials on record. Stop. This matter emanates from proceedings of the aforementioned police case, on an FIR dated.
The FIR is
dated. Sorry, I'm asking for because I'm not going through the petition.
21/1/2023.
Dated 21/01/2023, which had culminated in the final report being filed before the said court of the special judge. Stop. Wherein prayer for closure was made. Stop. The special judge, it appears, being dissatisfied with the informant's fellow Gamil. It appears that notice was duly issued to the informant, and on his appearance and being dissatisfied with the orders being satisfied with the response of the said informant, has, before accepting the final report, has called for the appearance of the petitioners and also of the auction purchaser, who it is stated is yet to leave the auction cold. Stop. Next paragraph. As submitted earlier by the council petitioners, the special court was constituted by the state government in the exercise of powers conferred under Section 30B of the Mines and Minerals Development and Regulation Act 1957, and for the purpose of providing speedy trial of offences for contravention of the provisions of Section 4 and bracket 1(1)(a). Stop. In the concert view of this court, at this stage, prima facie case was made out, and as much as since the matter only concerns the filing of FIR and the filing of the FR by the concerned investigating officer. Stop. The appearance of the petitioner doesn't seem to appear necessary in the normal course of business in dealing with such matters. Stop. Accordingly, interim, the impugned order dismissal shall not be given effective until the next date. We'll close the next date. You kindly give the other orders.
Yes, my lords, I'll supply that order. I'll go through it, my lords. It's a...
You ask the Advocate General, he is well aware.
Yes, my lords.
Yes.
Order
Just-
matter can
just
be
one
closed, Your
correction, my
Lordship.
lords. The
Can be closed, Your Lordship.
complaint was 2111, 2021, and the FIR has in fact been registered on 28/3/2022.
FIR 28/3.
FIR has been registered on 28th of March 2022.
28 March to 2101. We go to the next date.
Yes, ma'am.
Just give that order regarding auction so it will not clash with orders of the special bench.
Yes, my lords, I'll do that. Oblige, your lordship.